May I please your lordship? Lord, with the consent of the other side, my lord, I beg to mention item number 24, my lord. Order item, my lord. My lord,
20?
this IA has become infructuous, my lord. IA had been preferred for vacation of the order, my lord, dated 18/7/2025, by which, my lord, the suspension order was stayed, my lord. Now the delinquent officer has been dismissed from service after inquiry, my lord.
So we'll have it when the matter reach. When the matter-
Withdraw the case, your lordship. Withdraw the case, your lordship.
You are withdrawing the case.
Now, IA,
Sir, has been dismissed from service.
You are withdrawing the case. Say that.
IA,
No, no, writ petition are you withdrawing? Then
I am for the IA, my lord, government.
Mr. N. Gautam, the learned counsel appearing on behalf of the petitioner submits that the petitioner having already been dismissed from his service, comma, the instant writ petition has become infructuous and accordingly he would like to withdraw the same without prejudice to the right of the petitioner to challenge the same. Taking into account the above, the instant writ petition accordingly stands closed on withdrawal. Full stop. Liberty, however, is given to the petitioner to challenge the dismissal if so advised as in accordance with as per the provisions of law. In view of the withdrawal of the instant writ petition, the interlocutory application stands closed. Interim orders, if any, stands vacated.
May it please your lordship. Lordship, may I pray for listing of a writ petition for withdrawal, lordship? Can it be tomorrow, my lord? Oblige.
May I please, your lordship? Your lordship, I have filed one interlocutory application and pray for listing tomorrow, your lordship.
Why?
Because there is a connecting contempt application in which the personal appearance has been given on 9th. So for dispensing the personal appearance, I have filed this IA, your lordship. And in the meantime, we have complied with the order also.
Tomorrow the matter is there.
No, it is on 9th.
Then
Then, your lordship, I pray for tomorrow because we have already complied, your lordship. That's. I look.
That for listing writ petition for withdrawal.
tomorrow.
Wait, please, lordship. I beg to mention item number 23, lordship. Item number 23. It's a bench to matter, lordship. It was longly listed before this court.
Don't make these type of submissions. If the matter comes up before me, I take up all matters.
Lordship,
Being a bench 5 also, I'll take it.
lordship.
Next.
This took a petition, your lordship.
Huh?
Filed it on 30/12, your lordship.
Motion,
Motion, your lordship.
Wednesday.
Date, your lordship.
Wednesday. 7th.
7.
May I please, lordship. Lordship, daily list item 29, lordship. I may be withdraw this petition, lordship. Item
29, what is it?
Item 29, lordship.
What do you want?
29. Withdraw,
Ah.
lordship. Withdraw for
Huh?
withdraw, lordship. I
Withdraw?
withdraw, yes, lordship.
What's your name?
Are wrong, my lordship.
Ms. R. Rongme, the learned counsel appearing on behalf of the petitioner submits that the petitioner would like to withdraw the instant writ petition. Taking into account the above, the instant writ petition stands closed on withdrawal. Interim orders, if any, stands vacated.
Wait, please, lordship. Back to mention for withdrawal item number 10, your lordship. The contempt case. In the meantime, the department has replied, your lordship. The matter has stand infructuous.
Huh?
Matter has stand infructuous, your lordship. May I withdraw the matter?
What's your name?
Yes, lordship.
Mr. T. Loskor, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would not like to press the instant contempt application. Full stop. Taking into account that no notice has been issued in the instant contempt application, comma, the instant application stands closed as being not pressed.
May please, lordship. Lordship, I pay for listing of this matter on 7 for withdrawal order.
For listing, pensionary benefit.
Huh?
Pensionary benefit for listing.
So, for what? Motion, admission, pension. Okay. Let us have it after Bihu.
Maybe date.
Huh?
7.
7th? 17th. 17th is closed. 18th is closed. 19th.
I'm paying for withdrawal of this contempt.
Yes.
Withdrawal of-
Contempt you are withdrawing?
Yes.
Where?
Certain facts are required to be incorporated in the previous, the other contenders have not been added as the party list. The previous directory is also not there, so I have to amend the content.
Huh?
I have to amend the content petition, that's why I thought better to withdraw them and file the application. Deliver to contempt petition.
What is the order passed?
No, serve in this case.
Which order you are contempt?
6th of September.
Page 20.
Election comply.
Now what has happened?
Certain facts are not there, Lordship, because we submitted the representation, certain documents have not been annexed. And the concerned director who was there during the relevant period of time, he has not been added as the party. So this entire thing I have to change, Lordship. Praying for withdrawal, you can leave out with the file impression.
What about the limitation then?
1 year, 1 year is there. Lordship.
It will be over.
Starts from the date when I have submitted my representation. That is
No,
From the date of submission of representation.
your limitation has started. May be allowed to undergo so and so upon receiving the certified copy of the order. The certified
was
copy of
submitted
the
in the
order
month
was given on 11/9/2024. 11/9/2024. 3 months thereafter. Within 3 months it is to be given. So it is 11/12/2024. No, representations does not, but the limitation goes. You want to do it, no problem. But I'm not going to grant any liberty. Want to withdraw, withdraw. No problem. But this is, or I can say that liberty is given subject to limitation.
Then Lordship, after vacation, let me think about it. After vacation, Lordship, this view vacation, Lordship.
Why? Would it change it?
Let me think
I'm
about
here for next 6 months. Nothing is going
it.
to happen.
That, Lordship.
Nothing is going to happen.
Uh,
You want to withdraw, withdraw, but without liberty. With liberty, but subject to limitation.
Let me think over it.
Huh?
Then day after tomorrow, Lordship.
No, 15 minutes. 15 minutes, think
Then
of
I
it.
think, Lord, then I-
15 minutes. It should not go. Yes, what is this?
That Vishnu wanted to apply for a post, Lordship.
Ah.
He is visit 40 years, but the advisement was that the upper age limit is 38 years. So there
When?
is a when, on the basis of which I am claiming that I may be allowed to.
Suppose while
Apply for the post.
tribunal should direct the respondent to raise the upper age limit of the applicant for the post of assistant professor in that. What is your age?
Yes,
41.
yes, Lord.
So,
Page 25, there is a when which extend the upper age limit to 45 years. second para.
Where's the advertisement?
Advertisement case. lordship,
17. Yes.
My lord, that instruction I have got regarding my lord office memorandum. Lordship will see the para two, it says, my lord, it is as per the National Medical Commission. So it is only, my lord, related to MBBS. That too for the reason that, my lord,
Para?
that is para two of, my lord, page 25, that over.
Government after due have decided to revisit the existing upper limit for entering into government's.
Inconsistent with the regulation 2022 of National Medical Commission, with a view to sort out the issue of shortage of faculty members in the medical
This
college.
is only for senior resident tutors, demonstrators, registrars, residents. This is not
Resident physician.
assistant professors.
Not under, my lord, Ayurvedic college, my lord.
Scale of pay is same.
That.
Huh?
So scale of pay is also same.
Scale up pay, no.
Also, It is
But
entry level post in Ayurvedic college, it is entry level post.
No, but you are applying for assistant professor,
Yes,
isn't it?
yes, no.
The assistant professor is not there in the office memorandum.
And
Where?
you will take some instruction, lordship, tomorrow.
No. Today only. First. No case.
Don't want the dismissal this morning, lordship.
The upper age limit is relaxable as per government norms, orders, decision as applicable. You are applying on on the basis of office memorandum, which is not applicable.
I want a small time maybe. my lord.
Okay, 15 minutes.
Hello.
11:15. 11:17.
Tomorrow, lordship, because the.
11:17. His is 15, yours is 17. Okay, next.
Matter of conventional regulation of service of the petition.
What?
Regulation of service. Whether.
Regularization of service. Written the measure should not be issued. I have to complete the process of regular as early as possible. How many years?
From 1988.
Huh?
1988 Malay is serving.
Serving as
As
Khal-
well as-
Khalasi.
Khalasi.
His service was.
What is your instructions?
Lordship, I'm still awaiting the detailed instruction, Lordship.
Obviously, notice has not been issued. Why will you obtain instructions? We issue notice? Because he would otherwise come within the ambit of that Uma Devi case also. If he is there from 1988.
1988 with,
And more particularly when there is a government move at that point of time, Upennath's case. There also, I think, you have taken into those people who were there till 2005. There was a move 10 years
10 years.
prior to that. So here, if he was in 1988, he should have been
He should have.
regularized. Have you made up your case in that manner? No. Issue notice making it returnable on 2nd of March 2026. Mr. R.R. Gogoi accepts notice on behalf of all the respondents. Extra copies of the writ petition be furnished upon to him by tomorrow. The case of the petitioner herein is aggrieved by the inaction on the part of the respondent authorities in not regularizing the services of the petitioner, in spite of the fact that the petitioner has been working as a work charge Khalasi since 10/8/1988. Full stop. The learned counsel appearing on behalf of the petitioner submits that the case of the petitioner squarely falls within the ambit of the exception created by paragraph number 53 of the judgment of the Supreme Court in the case of Uma Devi versus State of Karnataka versus Uma Devi, reported in 2006, 4 SSC page 1. as well as the recent judgments of the Supreme Court, more particularly Dharam Singh versus so-and-so, reported in so-and-so. The counsel appearing on behalf of the respondent submits that the affidavit would be filed on behalf of the respondents on or before 2026. Was the petitioner given the liberty to reply, file any rejoinder thereagainst on or before 27/2/2026?
Obliged.
Contempt. What has happened?
Violation order dated 18/8/2025, my lord.
Where is the order?
My lord, and exact serial that is page number 26, my lord.
Page
26.
26. Reading the aforesaid vis-a-vis endorsement made by the learned counsel by in the interest deems it appropriate to dispose of the instance in terms with paragraph number 16 of the aforesaid judgment. Which department? PHE. Where is the PHE council? We saw a PHE council just now. And when did you serve this copy of the order? When did you serve this copy of this order? The counsel appearing on behalf of the petitioner submits that he needs 1 week's time to file an additional affidavit to bring on record that the order dated 18/8/2025 passed in WPC number 1132/2024 have been served upon the respondents of the petition. List accordingly on how much time? 1 week I have given. List the matter again on 2nd of February 2026.
Aye.
Yes.
My lord, in this case, the other side has filed an appeal. Great appeal, but then there is a delay. So, my lord, the notice has been issued, although we have filed caveat, no, my lord, the copy has been served to us. Today only we could continue.
So what should we do?
That is what I'm thinking, because although they have filed, there is no stay order. Obviously cannot be there because there is a delay in filing that great appeal. An appeal has not been registered yet.
You are for Augustha Bosumatari.
Yes.
Upon due consideration of any letter, this court finds that the impugned orders dated so and so are not sustainable and accordingly they are set aside. Any consequential steps taken pursuant to the passing of the area will also be there. If the impugned order dated so and so reverting the original to a lower post of remand has been interfered with amongst others, he shall be treated as continued. Necessary adjustment or refixation from the date of service of payment. Now, till now, they have not done anything.
But in the delay petition, notice has been issued. Although we filed a caveat, by law, no copy has been served to us.
Your caveat must have spent its force.
Have extended terms.
Hello, I think we issue notice, let's see.
That can be done.
Huh?
Notice can be.
Because till a stay is not granted.
Correct.
And what is this contempt?
Content.
Mr. Dutta,
I understand what you.
are you going to withdraw it?
I just told him, the first pair should be that only. Because it is not by name, so therefore I told my colleague also, so there is some defect in it. So my lord, as your lordship has said, better to withdraw and refile it by giving the name of the party.
Mr. S. Dutta, the learned senior counsel assisted by so-and-so submits that there are formal defects in the instant contempt application, taking into account that the contemners have not been arrayed by name. Full stop. Taking into account the above, the instant contempt application accordingly stands closed on withdrawal with liberty to refile by removing those formal defects.
Arising out of the non-compliance of orders dated 19/02/2025. Because if you have served the office, the respondent on 28/02/2025 and 04.
What is the time limit given?
There is no time limit given.
Huh?
No time limit given in the earlier. But already almost 10 months.
If the time limit is not given, order has been passed on 19/2. How there is a contempt?
10 months. Notice may be issued.
Notice I don't issue like this. It's a very difficult thing. Irrigation. No irrigation councils.
Notice may be humble prayer.
I don't issue notice like this. There's no contempt. When time limit is not fixed out there, what to do?
There's 11 months and completed.
Huh?
Almost 11 months is passed.
So what? They will do. There should have been a time limit in the order. Get hold of Mr. N.N. Upadhyay. Irrigation Council will do something. Yes, Mr. Rashid. Where is the direction? Page?
48.
48. What did I? For the purpose of determining the issue as to whether the residence of reserve falls within the coverage of the exercise now, yeah. What is the direction on receipt of the presentation from the petitioner shall schedule a date of hearing and issue notice in the matter. The petitioner and the respondent number 5 respond accordingly, so and so. And thereafter, upon hearing the party, they determine the issue as to whether the residence will be already. Now what happened? You are appearing for whom? Petitioner. Now notice has been issued? No.
No, ask me.
No steps have been taken.
We have taken, we have high representation, there is a page,
Where is your representation?
page 15.
Huh? Where is this a representation?
Man,
What representation is this? I have challenged the selection of so and so that upon perusal was pleased to pass an order. So where is the representation?
page 50 of the.
Mr. Counsel, you kindly come to page 48. Paragraph 12. In view of the above position, this court directs the petitioner to submit a representation. Where is your representation?
Page 50.
This is a forwarding letter. There's a difference between a representation and forwarding letter. Then submit a representation and then come over. Mr. A. Rashid, the learned counsel appearing on behalf of the petitioner submits that the order dated 17/7/2025 passed in WPC number 2212/2024 was forwarded to the Director, Women and Child Development, Assam by the communication dated 31/7/2025. However, as there was no representation submitted, the petitioner would like to withdraw the instant contempt application with the liberty to submit the representation as directed by the court in its order dated 17/7/2025. So taking into account the above, the instant contempt application stands dropped, giving, however, with liberty to the petitioner to submit a representation as directed at paragraph number 12 of the order dated 17/7/2025 in WPC number 2212/2024. And thereupon, if the petitioner is aggrieved, liberty is given to the petitioner to again approach this court after a reasonable period. Yes, Mr. H. Das.
Malad, page 11, Malad, is the copy of the order, Malad. One first grievance was initially, Malad, replaced because, Malad, date of GRS, Malad. Voluntary retirement was paid for, Malad, thereafter it was accepted. But. So,
Now, what is your grievance?
Malad, retirement benefit has not given to. Except the last letter, my lord, is annexure 5, page 46, 11,000 something, my lord. Office order.
What is this, page 14?
Yes, no, that is the only.
What?
Employees general insurance scheme 1983 and in persons of the OM dated so 11,1212 rupees only as savings money is hereby sanctioned to Onexonto Talukdar on 36/24 as he was a regular member of the so and so.
What else are you entitled to?
He was a regular employee. He was a regular employee. After all employee.
But don't you think you have to file a writ petition? In view of that order, kindly see page 11,
Yes,
last paragraph. The writ petition therefore stands closed by providing that the retirement dues as payable to the petitioner as per law be released without undue delay. If the petitioner remains aggrieved in the matter, even thereafter, it would be open to approach this court once again by filing appropriate proceedings. Don't you think a writ petition?
yes, that I may be allowed to. Would that liberty, madam?
Mr. H. Das, the learned counsel appearing on behalf of the petitioner submits that taking into account the observations made in the order dated 28/10/2024 in WPC number 5351/2023 and that only an amount of rupees 11,012 have been sanctioned in favor of the petitioner. The petitioner would be well advised to file a separate writ proceeding then to pursue with the instant contempt application. Taking into account the above, the instant contempt application stands closed. However, liberty is given to the petitioner to file a separate writ petition as per the liberty so granted by the order dated 28/10/2024 in WPC number 5351/2023 if the petitioner is aggrieved by the non-payment of its pensionary benefits. Where is he? Yes, fishery. Who appears for fishery? Anybody from fishery department? Fishery, there is no standing council. Nowadays, the government appears. If the government is not appearing, it's a different aspect of the matter. Then from next time onwards, none of the government councils can appear in my court. Because normally all fishery matters, earlier Mr. P. Sharma was there, but nowadays it is not there.
Then we will have to appear, my lord.
The government appears. So you find out why this order has not been. Yes. Mr. Chaudhary, we do one thing. You give a copy to him.
Yes. I'm not pressing this written application.
Don't withdraw.
Yes.
We issue notice, I won't issue a notice. I will only ask them to inquire why the order has not been complied with. We'll see
I will serve a
later.
copy.
Yes.
Number one.
The present application has been filed alleging willful and deliberate violation of the order dated 4/9/2024 passed in 6/9/2024 passed in WPC number 3182/2023. Full stop. The operative portion of the said order reads as under on hearing the learned submissions will দিব হ্যাঁ এখানে কোড করে দিব Full stop. This court had requested Mr. T. Sutia, the learned
Additional senior government.
additional advocate general,
Additional senior government.
additional senior government advocate, to inquire with the fishery department of the government of Assam as to whether the order dated 6/9/2024 passed in WPC number 3182/2023 have been complied with or not. Full stop. A copy of the contempt application be served by the counsel, by Mr. S.P. Chaudhary, the learned counsel appearing on behalf of the petitioners, to Mr. T.C. Sutia, the learned additional senior government advocate, for taking necessary instructions. The registry shall list this matter again for motion on 9/2/2026. Full stop. The registry shall also indicate the name of Mr. T.C. Sutia, the learned additional senior government advocate, in the cause list. You just find it out.
Obligement.
And this withdrawn, IA withdrawn. Mr. So-and-so submits that he would not like to press.
Let me, please turn to page 29. This is an earlier advertisement of the Ayurvedic school. For Ayurvedic college.
Hmm.
Here, the assistant professor, that is number 34. The age limit is 45 years.
Where?
Age 34. Here number assistant professor. Age 45 years. Earlier it was your lordship, after this, this poem that come after this advertisement.
Where is
Age 34.
45 years.
45 years. Because of the advisor of.
Assistant professor, where is it 45 years? 45 years. Okay. So,
Now, Lordship, in the new advertisement, it has made 38 years.
so are you challenging your advertisement?
On the point that that is, Lordship, otherwise I'm.
No, you have not challenged the advertisement. Then this court cannot increase the age. You withdraw and challenge the advertisement if you want to. That's the only way out then. Otherwise, you don't have a case.
Amendment application,
Amendment for what?
challenging this.
Then how do you keep the prayer?
For today, Lordship, matter may be adjourned. In the meantime, I said.
Why? You are the main counsel. Hardly matters.
To make some correction in the petition. My-
Correction by hand.
I will- no, Lordship.
Then?
Some amendment. To file some amendment application, I want some time. Lordship.
Amendment application for what?
Challenging the advertisement, Lordship.
No. Bad case. Hello, we dismiss
Yeah,
it.
maybe I'll- Bro,
Let me have the dismissal first of the day.
I'll do it when I shall-
I have been allowing withdrawal for all the contempt matters. No more withdrawal. I have to first get a
Wanna
dismiss.
answer the-
Huh?
wanna answer the-
Withdrawal with liberty. I give you the liberty for withdrawal. Heard Mr. R. Sharma, the learned counsel appearing on behalf of the petitioner, and Mr. B. Gogoi, the learned additional Advocate General Assam, who also appears for the Health and Family Welfare Department of the Government of Assam. Full stop. The petitioner herein have challenged, have sought for a writ in the nature of mandamus, thereby directing the respondents to raise the upper age limit of the applicant for the post of assistant professor in the advertisement number MHRB/70/GAC/AST.prof/2025/4748 dated 11/12/2025. The basis on which the petitioner have sought for the writ in the nature of mandamus is on account of an office memorandum dated 4/7/2023. Full stop. The learned counsel for the petitioner also have placed before this court that prior to the present advertisement, another advertisement was issued on 16th of March 2023, wherein the upper age limit of the to the post of the assistant professor was 45 years. Full stop. It is seen from the records that this court had sought for instructions from the respondents by an order dated 19/12/2025. Full stop. In pursuance to that, Mr. B. Gogoi, the learned additional additional advocate general, have placed before this court a set of instructions which is kept on record and marked with the letter X. From a perusal of the said instructions, it is seen that the advertisement is in terms with the Assam Ayurvedic Education Service Rules 2023 as notified by the notification dated 21/8/2023. And more particularly, Rule 7, which categorically mandates that a candidate for direct recruitment to the service of assistant professor shall not be more than 38 years as on the 1st January of the year of recruitment or as per the National Commission for Indian System of Medicine norms as applicable. Full stop. It is also mentioned that the OM dated 4/7/2023 is pertaining only for raising the upper age limit for entering into entry-level post of senior resident / tutor / demonstrator / register / register resident surgeon / resident physician, etc. at various medical colleges of Assam to 45 years, irrespective of any category of applicant. And in the said office memorandum, there has been no mention regarding raising the upper age limit of the recruitment of assistant professors in Ayush colleges. Full stop. The learned counsel appearing on behalf of the petitioners therefore submitted that in view of the said instructions, which is kept on record and marked with the letter X, the petitioner would like to withdraw the instant writ petition with the liberty to refile if so permissible and if so advised. Full stop. Taking into account the above, the instant writ petition therefore stands closed on withdrawal. However, liberty is given to the petitioner to refile by challenging the advertisement if so advised. You have a case, challenge the advertisement because you see, you have a copy of the instructions?
No, I have to.
Take a copy of this. See the other one. There are two. One is this one and there is another one. So it says that or is applicable. So there it says 45. So you have to challenge that advertisement. Oh, yes. Where is the council? Mr. Mr. Upadhyay, this is a case where these people were working as master role workers. With due respect to my coordinate bench,
Lordship.
there was a direction to implement the Upendra's case. But no time limit is given. So therefore, I would request you to obtain instructions as to whether any consideration has been made. Like the normally which I don't issue notice. I just request you to obtain instructions. This is an application filed alleging willful and deliberate violation to the order dated 19/2/2025 passed in WPC number 839/2025. It is relevant to take note of that by the order dated 19/2/2025, this court had directed the Irrigation Department of the Government of Assam to consider the case of the petitioners in the writ petition in terms with the directions passed by the learned division bench of this court in the case of State of Assam versus Upendas reported in 2017 4 GLR 493. This court requested Mr. N. Upadhyay, N. Upadhyay, the learned standing counsel of the irrigation department, to obtain instructions as to whether the case of the petitioners have been considered in terms with the order dated 19/2/2025. It passed in WPC number 839/2025. Full stop. The counsel appearing on behalf of the petitioner is directed to serve an additional copy, an extra copy of the instant contempt application to Mr. N. Upadhyay, learned standing counsel, irrigation department, to obtain, so that he is in a position to obtain instructions. Lists the matter on 9th of February 2026 for an update
Lordship.
in the motion column. Full stop. The name of Mr. N. Upadhyay shall be shown in the cause list.
Obliged, Lord.
Where is that counsel? That counsel has gone lost and found. Yes, what is this? Another contempt case. So many contempt cases. What is this case? All this, the judgment of the Gondali. What is the direction passed? No time limit.
But above 11 months of there.
Huh?
Above 11 months of there.
11 months is okay, but you see the time limit, without the time limit being given, it's very difficult. Finance, PHE. Any PHE council? You have retired?
Retired.
When?
Retired, Lordship. 2000 Lordship. 18 Lordship. One 29. Yes, 2019.
Mr. Council, there is no, what is the relief given to you? Everything has been rejected.
And some similar persons were considered Lordship by the department Lordship.
So wouldn't that be a separate cause of action? How can you enforce this order? Paragraph 16, read it.
But the circumstances, this code is of them that if
Other work charge employees working in other or similarly situated are extended the benefit of pension, then the case of the writ petitioner may also be considered for the grant of such benefit. How is it possible? So you need additional facts that somebody else has been there. There has to be a finding. Where is the finding?
consider that there are 15 lots.
No. There has to be addition. So there has to be an adjudication. This is an order. They have not considered it. Wouldn't it therefore a case whereby you will have to come up out there and say that look here, A has been given. I have not been given. And there is an adjudication to that effect that you have been given.
Order, paragraph 15 lots.
No, Mr. Counsel, I'm in contempt. No, can in a contempt, I adjudicate that.
While the
This is a something like a solace being given to the council at last after dismissing all prayers. You see, kindly see paragraph 13. There is no specific provision that pension would be otherwise available for temporary or work charge employees who have rendered continuous service for long years under the Assam pension, unlike Gujarat pension rules. Under such circumstances, the judgment will not be applicable to the facts. You said about Upendas is not applicable. Everything has been rejected. At last, the judge felt that, okay, looking into account, so many lawyers have appeared. Give me one liner out there. Under such circumstances, this court is of the view that if other work charge employees working in other or similarly situated departments are extended the benefit of pension, then a case of the return may also be considered for grant of such benefit by the government.
some orders was placed before the court, Lord.
Huh?
Some orders was placed before the court also. Wherein the others.
So therefore, if those are the cases, it is a something to be adjudicated upon. Where? Of? Yes.
Paragraph 53.
Specific issue. Yeah. As to whether master roll are entitled to this has been negated by the judgment of the same is therefore binding on this court. The learned council has placed that this court may an order passed in other similarly situated workers who have considered to be eligible for grant of pension. The related shall not did not file any affidavit to such averment, nor they have disputed. So that case, no case. Chalo, we dismissed. Your case comes first. I've not been able to dismiss any case today. Yes, Lekhok. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner.
Dr. Parakule allows to go ahead.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. This is an application file alleging willful and deliberate violation to the order dated 26/2024, passed in which one?
WBC 5343/2021.
এইটো নামটো পালে নহয় 5
5343 of 2021.
5346/2021.
43 5343.
5343, where is it? Anyways, 5343/2021. 5343/2021. Full stop. This court have duly perused the order dated 26/2024. And from a perusal of the said order, it is seen that the learned courtnet bench had rejected the contention that they are entitled, that the petitioners herein are entitled to pension. However, it was also observed that if other work charge employees working in other or similarly situated departments are extended the benefit of pension, then the cases of the writ petitioners may also be considered for grant of such benefit by the government. It is the opinion of this court that without there being an adjudication that in similarly situated departments, pension has been granted to work charge employees, no case of contempt has been made out. During the course of the dictation of the present order, the counsel appearing on behalf of the petitioner therefore submits that he may be permitted to withdraw the instant contempt application and file a separate writ proceedings indicating that in similarly situated departments, work charge employees have been paid and the petitioner's case have not been considered. Considering the above, the instant contempt proceeding stands dropped without prejudice to the right of the petitioners to file a separate writ petition if so advised.
Item 11.
But in this case, direction was to regularity, my lord, husband of the petitioner service, my lord, after the phase 14, my lord, after his date, my lord. And
Master
thereafter
roll.
he is Master roll employee.
8/6/1984,
Yes, my lord. he joined.
contempt, Public Works Department, PWD, any PWD council? What has happened? They have not done it.
My lord, only the letter kindly peruse page 30. Information supply in view of the letter of the additional chief engineer.
Hello. We should notice this. Issue notice making it returnable on 9th of March 2025, 26. The petitioner the steps be taken upon the respondents by way of speed post by tomorrow. The case of the petitioner herein is that the order dated 14/8/2024 passed in WPC number 7439/2022 have not been complied with. First, the respondents herein are directed to bring on record their stand by filing affidavits as to whether the order passed by this court dated 14/8/2024 in WPC number 7439/2022 have been complied with or not, and if not, the reasons therefore.
Right, ma'am.
12.
Huh? I passed that order. You give a copy. That is the irrigation department, na?
Yes.
You give a copy to Mr. N. Upadhyay now only. He will take instructions. We'll look into it. Or this one. Somebody wants to. What is this?
Your Lordship, the transfer order on posting was put to challenge. There was a promotion.
Transfer?
There was a promotion to the cadre of matron and Pearl, Your Lordship. So that was put to challenge by the petitioner.
Then
So-
there was a stay.
There was a stay, but the stay was modified, Your Lordship.
Then what happens?
Your Lordship, then thereafter the matter came up today.
Huh?
The matter came up today after that, Your Lordship.
Till the next date, the order as pursuant, so insofar as the writ petitioner vis-a-vis private are concerned shall remain stayed.
Yes, Your Lordship. Now, Your Lordship,
Then
kindly see the.
There is another order that upon hearing the parties, this court while issuing notice has granted stay.
Your Lordship,
That
will
as
kindly
it
see the
may,
I application.
Since the interim order has already been passed and now the vacating period has been filed, this court intends to issue notice permitting the respondents to order stands modified to the extent that the status quo as on date shall be maintained and the service benefits of the private respondent shall not be affected by virtue of the interim order which now stands modified. What is the modification?
Your
The
Lordship,
date on which the order was passed staying the promotion order dated demand had already joined in a place. It is clear that by virtue of the stay granted by this court by the remand, the status of the private respondent will be under cloud. This court perhaps would not have granted the as the facts may be already joined. Yeah. So you joined earlier,
Yes, Your Lordship. In
and
fact,
therefore the petitioner counsel is lost in
almost after a period of more than 1 month. The transfer order was passed on
Hello.
26th, promotional order. I joined on 27th.
None appears on behalf of the petitioner on call. Full stop. This court have also seen that the interim order which was passed on 23/7/2025 have been vacated by an order dated 13/8/2025. Considering the above, comma, it therefore appears that the petitioner have lost interest in the instant proceedings. Accordingly, the instant petition stands dismissed for non-prosecution. I stands closed.
Deeply obliged, your lordship.
13.
What is this?
My lord, this has been filed against the appointment of respondent number 5 as the Gao Pradhan. My lord, but in this, there is evidently an error in the prayer part. I filed an IA for amendment of prayer matters.
What?
There is a prayer for change of a prayer part, an amendment has been filed.
IA for
IA has been filed.
prayer amendment.
Yes, my lord.
Okay. Added prayer.
Yes. All
Okay.
numbering has been mistaken.
Chalo. Issue notice, issue no lie. This is an application filed seeking amendment of seeking insertion of an additional relief to the accompanying writ petition. So I've heard Mr. So-and-so, the learned counsel appearing on behalf of the applicant, oblique the petitioner, and Mr. T.C. Sutia, the learned additional senior government advocate, who appears on behalf of the respondents.
2, 3, and 4.
1 and 3.
And 5. Full stop. Taking into account the above, comma. Taking into account that no notice have yet been issued in the accompanying writ petition. It is the opinion of this court that the relief which have been sought to be inserted by way of the additional application by the present application is required to be allowed. Accordingly, the relief, accordingly, the petitioner applicant herein is permitted to, accordingly, the instant application stands allowed, thereby permitting the applicant to add the reliefs as sought for in the sought for.
Block 87. 5.
At paragraph number 6 of the instant application. Full stop. I stands disposed. Full stop. Mr. Tate Hekonote Hiwai, the counsel appearing on behalf of the petitioner is given 7 days time for filing the amended writ petition.
My lord, one thing, my lord, petitioner has prepared an appeal, Assam Land and Ability Regulation, executive instruction against the appeal, Section 4 162D, the review.
It's okay, there's no worry with that. The motion notice has not been issued. So after 1 week, we'll dismiss it on the alternative remedy. Giving 1 week's time to file the amended claim, amended writ petition. So IA allowed, Econo Divo, yeah. List the matter after on 21st of January 2026.
22nd, my lord. 22nd.
Why?
My senior.
We do one thing. We amend it. You file an amended petition, we'll look later on. Now we dismiss it in your hands. 21st.
Okay.
There's a big out here given now. Number 2.
Hello, in item number 12, advocate has been changed. We have been engaged newly much.
Which one?
Item number 12,
What is item number 12?
So I think just now, my lord, your lordship has passed order to dismiss for the non-prosecution.
No, there's nothing out there.
My lord, we have been newly engaged. my lord.
So what? Nobody was appearing.
No, today the first day, my lord, we got, our name has not been, my lord,
How do I know?
kindly, my lord.
File restoration? No. Or argue?
My lord,
Or argue?
yes, my lord.
Or argue the matter.
Yes, my lord.
Let me come back. We'll argue, call the other side.
Yes.
We'll argue and we'll finish it off today. Your transfer matter, na?
Yeah, no,
You came
no
after
transfer,
1 month.
Promotion and transfer and posting, my lord. Promotion and posting.
So it has been modified.
Yes, modify.
Nothing remains.
Let the matter may come on Friday, my lord, and you'll also be pass manager on.
No. Friday, no. 12:10. 12:10. Matter will come up.
We are newly engaged, my lord, because
So
many
what?
things are there, and we have to file IA also, one IA we have to file.
So you better file two IAs. One for restoration and the other for debt. Dismiss. Mr. Sinha, call your other counterpart. He is also a Sinha.
Yes,
Get hold of him. Yes, where is the other side? You file your affidavit.
In this matter, my lord, there's an issue regarding the point of maintainability of the writ petition. Because, my lord, the services under railways are included as serial number 50 of subpara B of that, my lord, 1993 rules of practice, CATS rules of practice. So, my lord, this petition is not maintainable. So, I am on the very motion stage, my lord, I raised an issue on the point of maintainability, and they were supposed to, my lord, address the court on the point of maintainability today.
When did the person die? When?
27/5/2020.
Then?
27/5/2020. After that, one, she approached CAT, my lord.
Huh?
Yes, she approached CAT first. CAT passes an order. After that, we pass a speaking order. Against the speaking order, he has come before this honorable court. Now, she may kindly come to annexure 16, my lord. Last annexure. At page 44. First, my lord, she approached CAT, my lord.
What is FS dues?
But I am not aware of this.
Huh?
I have to get instructions, my lord.
Then? You are relying on a document which you don't know?
Because I'm yet to get instructions on this one.
And where is the scheme?
He is not annexed, my lord.
Then?
He is not annexed there.
Do you have a scheme?
Yes, there has to be, my lord. No, he has not annexed anything, my lord. She has not annexed.
Wait. This is Musumi Balmiki. Unless they enclose the scheme, where is the
Yes, my
question?
lord. She is claiming, my lord, compulsory upon the death of her mother-in-law. my lord.
There has to be a scheme, na? You have a scheme.
I don't have right now, my lord. There has to be some scheme, my lord.
The notice was issued, na?
No,
Yes.
no, my lord. Today was supposed to
Notices are
address the
not
court on the
issued.
issue of
Extra
maintainability.
copies be furnished to the.
29/10/2025 order, my lord.
Yeah, so what is the instructions you have?
My lord, we are not, we're not asked to get instructions, my lord. He was supposed to address the court.
Have you seen the order of 29/10/2025?
Yes, my lord, Mr. Respondents have not related to the request made by the petitioner, therefore the writ petition has been filed. MR Adhikar, Lana CCC at the outset has raised objection with regard to the maintenance of the writ petition. He submits that on the earlier occasion, the writ petitioner has approached the Central Administrative Tribunal, CAT, therefore the writ petition is not maintainable and the proper forum is the CAT. The London Council for the petitioner will address the court on the issue, on the question of maintainability before issuing the notice in the matter. Although notices are not issued, extra copies are furnished to the learned series were responded to obtain required instructions in the matter. So I'm sorry, madam. I missed it. Let it be in the next, after vacation, madam.
Where is this council?
Lordship, I kindly come to Rule 154 of, madam, that 1993 rules of practice, madam.
Page?
In this book, madam.
What book is this?
This is, madam, Administrative Tribunals Act 1985.
What does it say?
Well, 154, I just read it, madam. Classification of cases subject-wise, department-wise. The scrutiny we shall at the time of scrutiny make classification of the cases as follows.
Page?
Well, page in this book is 65.
Yes. Restriction on appearance.
No, but classification of cases, my lord. This is, my lord, Central
Rule
Administrative
65.
Tribunal Rules of Practice 1993.
Which rules?
Rule 154.
Oh.
Page, my lord, 65 in this book. My lord. I have it.
Rule 154 of
What-
which one?
Or the 1993 rules of practice, my lord.
Classification, the
Yes.
scrutiny of branch of the year
Yes.
shall be as,
Yes.
department.
I'm on B, my lord. The department-wise classification shall be made in accordance with Appendix 6, as may be modified by the chairman from time to time. Now, my lord, lordship will find that at page 103, Appendix 6. 103, my lord.
Yes.
Yes. Lordship may kindly see, my lord. Appendix 6, my lord, department-wise Rule 154B, department-wise classification of cases. Lordship may kindly come to serial number 50. But this is Ministry of Railways. So, my lord, the services under Ministry of Railways are covered, are included in, my lord, the serial number 32 of, my lord, subpara B,
Serial number?
32.
Ah. So it is covered by what?
So, my lord, it is covered, so, my lord, the CAT will have the jurisdiction to entertain these petitions, my lord.
CAT will have the jurisdiction to entertain the petition is another aspect.
Yes, my lord.
That doesn't take away the jurisdiction of the
And again,
state.
my lord, L. Chandra Kumar's case, my lord, Lordship may kindly come to, I have not given the list of dates, my lord. 1997 3 SCC 261, मतलब para 93 मतलब that special bench मतलब 7 judges bench has decided, has held. Let me read मतलब para 93, the relevant part.
You are referring to L. Chandra Kumar?
Yes, yes,
L. Chandra Kumar's cases on Article 320,
Yes.
323A.
yes. Let me read मतलब
Now, Mr. Adhikari,
Yes,
let
yes.
us not jump there.
yes,
You see, this is against whether an appeal will directly lie to the Supreme Court
yes,
or whether the High Court under 226 can have
yes,
jurisdiction.
yes,
The court held
yes,
that that the High Court could have the jurisdiction, taking into account that
yes,
Article 226 is also a basic feature of the Constitution.
yes, ma'am.
But it said that it will go to the division bench.
Yes,
This is
yes,
that is one aspect.
Yes.
Now here is the case
yes,
where he moved an application before CAT
yes.
seeking some retirement benefits,
Compassionate appointment, anyway. Compassionate appointment,
retirement benefits along with compassionate
my
appointment.
lord,
Now the court said that kindly consider these two.
my lord,
There are two representations
Yes.
made in the month of August.
yes,
Kindly consider these two
Yes.
representations
Yes.
and dispose it by a speaking order.
yes,
Now the speaking order is there at Annexure 16,
my lord,
which you also don't know what is meant by it.
FS, yes,
You also don't know.
yes.
So
Let me read,
how
my lord.
will L. Chandra Kumar come into
Yes,
the picture?
let me read para 93, madam. Para 93 of Chandra Kumar, L. Chandra
Not
Kumar.
necessary.
Just
That is for the division bench.
for my satisfaction, madam.
That is for the division bench. I don't have any satisfaction. But the question is,
For my satisfaction,
why
you
you
also
have
kindly hear.
not passed
listen
the
to me.
reasoned order?
Yes,
The reason order is not there. You say, we have paid you the dues.
yes,
There's no quarrel with that.
yes,
Whether he is entitled to the compassionate appointment or not.
yes, yes. But the former satisfaction also may kindly, my lord. I just want to read it, my lord, the last 7 lines of para 93, my lord.
Okay, read
Yes,
it.
yes, madam. We may add that the tribunals will, however, continue to act as the only courts of first instance in respect of areas of law for which they have been constituted. By this, we mean that it will not be open for the litigants to directly approach the high courts, even in cases where they question the virus of statutory legislations, except as mentioned, where the legislation which creates the particular tribunal is challenged by overlooking the jurisdiction of the tribunal concerned. So, since one of these matters, Lordship, I just have taken a lordship to that particular provision, Mala. The services are of railways are included. It's serial number 32, my lord, of this of appendix 6. So, Mala, the CAT will have the jurisdiction. CAT is the CAT will have the original, it will have the jurisdiction where Mala, they have to approach. And accordingly, Mala, rightly so, they had approached the CAT in 2023. Yes.
None appears on behalf of the petitioner on call. Mr. M.R. Adhikari, the learned CGC, appears on behalf of the respondents. The petitioner herein have approached this court
Okay.
by challenging the speaking order dated 24/3/2025 passed by the Senior Divisional Personnel Officer, NF Railway Lamding, and further sought for direction that the case of the petitioner, that the application of the petitioner for compassionate appointment in the Group D post or any other post be considered Pusto. Mr. M.R. Adhikari, the learned counsel CGC, appearing on behalf of the respondents, however, submitted that the instant writ petition is not maintainable. In that regard, he has referred to the Central Administrative Tribunal Rules of Practice 1993, and more particularly to Rule 154, read with Appendix Roman 6 of the said rules of 1993. The learned counsel also referred to the judgment of the Constitution Bench of the Supreme Court, rendered in the case of L. Chandrakumar versus Union of India and others versus reported in 1997 3 SEC 261. In the backdrop of the above, let this court take note of the brief facts which led to the filing of the present writ petition. The case of the petitioner herein is that the petitioner is the daughter-in-law of one Kiran Balmiki, who died in harness on (27/5/2020). The records reveal that the petitioner thereupon submitted various representations seeking for the pensionary benefits as well as for appointment on compassionate basis, on compassionate grounds, on account of the death of her mother-in-law while in service. The said representation having not found any favor, the petitioner approached the Central Administrative Tribunal Guwahati bench by filing an original application number 040/00365/2023. The said application, filed before the learned Central Administrative Tribunal Guwahati bench, was disposed of by an order dated 6/12/2024, whereby there was a direction issued upon the respondent authorities herein to consider the last pending representations of the petitioner submitted in August 2021 in accordance with law, as well as observations as made, as well as taking into account the observations made by passing a reasoned and speaking order within a period of 3 months from the date of receipt of the certified copy of the order. The said order, order dated 6/12/2024, passed by the learned Central Administrative Tribunal, was served upon the concerned respondent authorities. In pursuance thereto, by an order dated 24/3/2025, the request for appointment on compassionate grounds was rejected. It was not rejected, na? was not rejected.
Yes, my lord.
By the communication dated 24/3/2025, the pensionary dues of the petitioner have already been paid to one Miss Pooja Balmiki, the daughter of late Kiran Balmiki. However, on the aspect pertaining to compassionate ground appointment, it was mentioned that no such application has been received in the proper format. In the backdrop of the above, the question therefore arises as to whether this court should entertain the challenge to the communication dated 24/3/2025. In this regard, this court finds it pertinent to take note of Rule 154 of the Central Administrative Tribunal Rules of Practice 1993. Which classifies the cases subject-wise / department-wise. Further to that, a perusal of Appendix 6 reveals that amongst the various department-wise classification of cases falling within the ambit of the Ministry of Railways fall within the domain of the Central Administrative Tribunal. This aspect is also very clear from the fact it also appears also to be an admitted position on part of the petitioner, inasmuch as the petitioner had initially approached the Central Administrative Tribunal. In this regard, this court also finds it pertinent to take note of paragraph number 93 of the judgment in L. Chandrakumar Supra, which is reproduced herein under. Taking into account the above observations of the Supreme Court in the case of L. Chandrakumar Supra, as well as the Central Administrative Tribunal Rules of Practice 1993, it is the opinion of this court that the challenge to the communication dated 24/3/2025 has to be first maintained before the Central Administrative Tribunal, Guwahati, if so advised, rather than approaching this court at the first instance. Considering the above, on the ground of maintainability, this court is not inclined to entertain the instant writ petition. However, the non-entertaining of the instant writ petition shall not prejudice the petitioner to approach the Central Administrative Tribunal, Guwahati, if so advised.
Right.
Hence disposed. Yes, where is that mean both sinners? 93 to Bhorai Diba. Yes. Argue. What Friday? Nothing remains. You have filed your affidavit.
Your Lordship, I filed the stay vacating, but affidavit I have not filed, Your Lordship. I'll file it Your Lordship, otherwise your Lordship can hear in it's purely a law point, which says that once you have been promoted and you have been given a posting, you cannot have a choice of posting of your own choice. That's the law, your Lordship.
He
Now,
wants it at a particular place.
if your Lordship, I just place the facts in this manner. Out of 30 years of service, the petitioner was posted for 29 years and 9 months in Dorong district. And on promotion, she was transferred to Dibrugarh and the GNM training school. And she didn't join there. And she filed the writ petition on the false plea that she is there still. She filed the writ petition saying that a stay should be granted in her favor because she wants to be there in Darang. Now, a stay was given, but when the facts was produced before this honorable court, this honorable court was inclined to vacate the stay. If your Lordships kindly come to my stay vacating application,
What is the name of the petitioner?
Krishna Hendik.
Huh?
Petitioner name is Hevali Devi. Hevali Devi.
Where is she? Where is the impugn order?
Order. you got
Annexure
two
E.
points.
Huh?
Two order has been passed. First,
Impugn order is at page 27, your Lordship. Annexure E.
Sevali Hendik.
No, Hevali Devi and Krishna Hendik.
next 28.
Joint Director Health Service Mongoldoi, Principal Tutor to, what is this?
GNM,
What is the GNM?
that's a nurse training. Mandal.
General Nurses and Midwifery Training School. She was appointed as a principal in that school and she was supposed to join within 15 days. She filed this case after a period of almost 1 month. So that order also goes, your Lordship.
And in the meantime, you joined.
I joined the very next day, your Lordship.
That's why Malad,
Stay order was
that was
modified.
vacated in respect of her only.
Then,
Malad,
what does the Director of Health Service say?
representation was filed, my lord. That was not disposed of under. That also, my lord, representative to dispose of them, my lord.
I don't know. I normally take bench 4, bench 5 matters, but the representations normally, as I could see, first you have to join there and then submit a
Yes, your
representation.
Lordship.
Isn't it the law?
Yes, your Lordship.
The thing is that two order has been passed, my lord. First has been passed on the same day. Subsequently, another order has been passed, modifying some place of posting. So there I was one of the candidate, my lord, where the modification has been done.
How many years of service you have?
6-7 years.
Then you take compulsory retirement?
Because
Voluntary, no?
that is-
Compulsory?
Yeah,
Give a compulsory retirement.
Because there's a
She
vacant
wants
post.
to remain in Dorong, let her remain in Dorong forever.
There is
Huh?
also vacant post. my
You,
vacant-
you accept compulsory retirement? No, not
vacant post is
voluntary.
there, my vacant post is there.
Not necessary. This court is not going to look into all these things. What is the malafide out here?
There. One candidate, that is the candidate serial number 6, Khateja Khatur, in respect of her posting has been modified.
No, what is the malafide out here to send you to the Dibrugarh? Then matter over.
Hello.
Where is the judgment of transfer?
I'll-
1994 6 SCC 1 judgment.
I'll give
Then
it.
the promotion on transfer.
Very good.
But what about the-
You don't want promotion also. Then?
Promotion and posting, your Lordship.
Then,
She was promoted and she was thereafter transferred.
let us finish it today itself.
Yes, sir.
Matter.
Newly engagement, but newly engagement on Friday, my lord, matter, my lord. Friday,
Okay.
matter, my lord.
10,000 cost?
Well, Friday, my lord. Because I have to go for it, my lord. Friday, my lord.
Go for it. Then you'll say on Friday, Bihu is coming. Not, don't spoil my Bihu.
Okay, before that, I want to file an higher, my lord, because some
I for what?
vacant posts are there, my lord. I may be appointed there.
Absolutely no. This has no business. Those type of mercy is gone. Somewhere it was dying out there. Mercy I don't have.
There's a Khatul, my lord.
No
Para
Khatul
6,
people.
your Lordship.
Duty of the governments who comply with the transfer have the tendency of not reporting at the new place, instead indulging in litigation to ventilate grievance held, not new period. There is na compulsory retirement. Yes.
Para 6,
Well
your
done.
Lordship. Para 6. We have perused the records.
Have you joined out there or Dibrugarh or not?
No.
Mr. Take steps for compulsory retirement. Here it is given. I am not saying this. Supreme Court says
In fact, there is a judgment
the
by your lordship
non-compliance
also.
with transfer order for long period coupled with successive leave applications, compulsory retirement grounds, long authorized leave. No, good ground.
No, madam.
Let me record that also.
No, that thing is.
No,
that,
no,
madam,
let
he
us
has-
record
he have- He has played before the authority, that I should be posted in the.
There is also
File-
one
file to
judgment
the-
that one has to go there,
File to improve order.
then you submit a representation.
This is the judgment, para
This
6.
is also there, na?
Para six.
No, I will
File to
write.
improve order, file to improve order.
No, that is a bad case.
Anything is done, I may consider in the Durham district.
No,
That was accepted, man. Later on, this has been modified, man.
no case, no case, no case. No case. You have joined?
Yes, I've joined, I'm serving your lordship.
I will just adjourn the matter and say that if he doesn't join, you are at liberty to take action. Chalo.
Your lordship, in fact, the posting order says that
And
within
that is
15
your
days.
lookout. Okay, you say you are new counsel. Okay. Heard Mr. B. Sainad. Now I'll observe that you are a new counsel. That is why I'm adjourning it. Newly engaged. Your name, you have filed Wakalatama or not?
No, not yet, my lord.
Eh,
That's why, my lord. Today is the first day come, my lord.
Mr. Mr. Sinha, first you are a persona non grata. Absolutely, you have no business out there. You have not filed Wakalatnama and I'm hearing you. I recalled an order. I think we should get hold of this counsel for the petitioner, Mr. R. Day. Why is he not representing? Where is he, Mr. R. Day?
He withdrawn himself, my lord.
Where is the withdrawn application?
Yes, my lord.
And you have not filed your Wakalatama?
No, obviously said there, but today is the reopening the first day.
So,
Today is the first day, my lord.
so this happened long time back.
No, no. The NOC have, NOC they have received only on. 2012. 2012, this is December, my lord. Today is the reopening day. I am coming today the first time. That's why I said.
You are not coming to the first time. You are more like an amicus curiae before this court. Nothing more than that. You have no business out here.
That's it.
Okay, anyways, none appears on behalf of the petitioner on call. I can't record your name. You are nobody. Mr. R. Sinha appears on behalf, Mr. B. Gogoi, the learned additional Advocate General appears on behalf of the Health Department. And Mr. R. Sinha appears on behalf of the respondent number 5. It has been submitted by Mr. R. Sinha that the respondent number 5 has already joined the place of posting prior to the filing of the writ petition.
Correct, your lordship.
Full stop. Mr. B. Gogoi, the learned additional Advocate General, submits that the Director of Health Service has already filed the writ affidavit in opposition, and the petitioner was given a promotion and posting. By the impugn order dated 25/6/2025, and for the last 6 months, the petitioner have not joined there and not joined there. The learned additional Advocate General further referring to the judgment of the Supreme Court in the case of S.C. Saxena versus Union of India and others, reported in 2006, 9 SCC 583, submits that the Supreme Court in the said judgment had categorically observed that long absence amounts to is a good ground for compulsory retirement. This court, however, would not like to comment on the same. However, in as much as it shall be absolutely within the domain of the respondent authorities to take such action as deemed proper. List the matter again for the interest of justice. The matter stands adjourned to be listed again on how much?
Next Friday, man.
Huh?
Next Friday or after the reopening.
After reopening, we have it in the month of July. By that time, your job is gone. Today in the morning, I found one matter of suspension. He has come up that I have already been dismissed. let us also come up that it has become infructuous that it has been dismissed.
Because he has submitted representation. Madam.
Hey, representation, nothing. Okay. And June 25? Huh? Okay, 9th of February.
The opinion of leave vacation. Madam.
Deeply obliged, your lordship.
Mr. Sinha, first you are, I told you, persona non grata. What is this? Motion?
Yes, Lordship, compassionate appointment, Lordship. 2016, Lordship.
Yes.
My lord, the petitioner's father died, yes, in 2016. He was under the consideration for compassionate appointments thrice. First in 21, then again in 22, and now in 24. But in all cases, his case was on the first matter, which was in 2021, that is 7th and 21. He was not given the chance.
Where is that judgment, Debabrot?
Devabrata Tiwari, Lordship.
Dismiss your petition.
My lord,
Dismiss. These
but
are, these are.
they haven't considered his case being true honor. There was administrative error from their side. They have themselves accepted that there were posts available, but he was not provided because they were informed late.
How are you surviving? 2016, 9 years.
Not explained.
It's not a right. Compassionate appointment is not a right. It is an exception. What is your right? Article 16 violation. You have used this copy so many times that it has changed the color also.
So many cases comes.
Okay.
My lord, but they themselves have stated, and there were 22 available posts, and there is an office performer available. I have annexed it here,
So what?
but they haven't given him the chance.
So what? You are 40 years. Then what were you? How are you surviving? Your father died when? 2016, which means 9 years back, 31. What were you doing from 31? As of now, today you are 40.
Yes.
Yeah. 31 years, what are you doing? How are you surviving the last 9 years? Isn't the compassionate appointment form basis is that there is an immediate requirement of a, because the breadwinner of the family has already finished, he died. So there is somebody to immediately take care of it. Well, immediately is 9 years. You have been able to take care of yourself by 9 years. Too delayed. That case. Even at that point of time, the office memorandum which was holding the field also says that 2 years, if it is gone, the matter over. Isn't it?
Immediate.
My lord, 24 they have considered, there were 22 posts left. At least for the next DLC, he can be referred, because there are still available posts. Because the performer is very fresh. There were 22 posts available, my lord.
Posted. Well, let it go to somebody who is actually in necessity. Not your case. This comes under the 2015. You had filed earlier with petitions.
The petition was for non-consideration, then the court allowed, this honorable court itself allowed.
Entire exercise shall be done in the next DLC meeting. Then what happened?
Then they had considered, and
Then rejected it.
in that first, the DLC.
After this order passed by the coordinate bench on 14/12/2020, what happened?
The DLC meeting happened. In the
Ah.
DLC meeting, they informed all the candidates that there were no available posts.
Then matter over.
But later on the next date, that is 8/10/2021, the office in charge informed that there were available posts of 3, but due to their error, they were unable to inform the DLC about the availability of it.
Where is the document?
My lord. Annexure 7, page 34.
Yes, what did you say? Which one?
35 here. Sorry. Last paragraph, the application of the four applicants were discussed as per, and in the very last line, that is dated 8/10/21, in which it seems that posts are available under compassionate quota. But they have informed them late.
Then what happened? Hence, it is decided to direct the officer concerned to place the entire proposal, which were not recommended earlier due to lack of vacancy, along with the financial status in the next DLC meeting for consideration. Then what happened?
Then in the next DLC meeting, my lord, that is 10/5/22, annexure 10, page 42. There were.
Annexure?
Annexure 10. Annexure 10 starts from 42 and the relevant portion is in 43. There were 12 candidates, out of which they have stated that the available three post one has been already filled and there are two posts available. And so they were asked to list all the candidates' name who and submit the same to the DLC immediately for the next consideration. It is in page 44, first paragraph. Then subsequently, annexure 11, page 45. His name has been specifically mentioned with all the details and available post for grade 4, which he has applied, that is 22. But despite that, on the final, that is the latest DLC, that is in 2024, they have informed both the candidates that there are no available posts.
Now tell me, there is another thing, na? When did the notification come in? There is the compassionate appointment notification. Where is that?
15, 2000.
Huh?
15.
The OM is 15.
Where is that
Lordship.
OM?
Yes.
1st June 2015.
You have not enclosed. The basis is that. Then there is another one, na?
Lordship, it is 17, 2017 new policies adopted, Lordship.
What is that?
That Lordship, now the compassionate appointment gone, Lordship. Now full salary will pay to to his successor, Lordship. That is the new policy, 2017, Lordship. Now, yes, compassionate family pension, Lordship.
Then?
So,
But
then-
he falls under 16.
Yes, he falls under yes, Lordship, 2015, Lordship. 15 OM, Lordship.
Okay. Then this was sent in the year 2023. Then what happened?
Hello?
What happened thereafter?
But, my lord, now the latest DLC meeting states that he is not eligible, which he cannot be recommended to the SLC because there is no available post.
Huh?
But that is.
Controller has been discussed in the meeting. During this, it is seen that the proposal was earlier discussed in the DLC meetings dated so and so, so and so. As per the Honorable High Court's order, the matter was considered in the meeting, but due to non-availability of grade 3 and grade 4 under the compassionate quota in the parent office, as well as other officers in the district as per the qualification we have proposed was not approved. So you are challenging this.
Because they, in the annexure which I have given as 11, they have stated like with name in that column that there are 22 posts available.
2 posts.
22. Grade 4 available post annexure 11 for page 45.
Where 22 posts?
Last
Yeah.
column, my lord.
No, it is he who is writing. Now, here also it is seen that there are 2 posts. Yes, why it is not done there?
Sir, I have to take instruction, Lordship.
Hello.
Court.
We won't dismiss. What are these?
I need a court letters. Right? Yes, no? Percent of post.
You get your instructions on this aspect.
Lordship,
Because earlier it has been considered why page 48,
page 48, Lordship.
19th?
19, Lordship. Lordship.
Issue notice returnable on, not 19th, 21st. 21st of January 2026. Mr. J.K. Goswami accepts notice on behalf of
All the respondents.
all the respondents. Extra copies of the writ petition be furnished upon him during the course of the day. This is the second round of litigation, whereby the round of litigation. In the first round of litigation, that is WPC number 1593/2018, the learned coordinate bench of this court directed the consideration of the case of the petitioner for appointment on compassionate grounds, for compassionate appointment. Full stop. It is noticed that the petitioner's case was considered in various meetings, that is on 7/10/2021, 31/12/2021, 7/3/2022, and 10/5/2022. But there was no recommendation made on account of an incorrect assumption that there was no vacancy. However, by the minutes of the meeting held on 31/2024, the application of the petitioner for compassionate appointment was rejected. By stating that there was no availability of grade 3 and grade 4 posts under the compassionate appointment quota in the parent office as well as in the other office in the district as per the qualification of the candidate. This ground, which have been taken to reject the case of the claim of the petitioner, is however contrary to the minutes of the meeting held on 10/5/2022, as well as The communication issued by the officer in charge, ICDP Silchar, to the additional Deputy Commissioner Kachar Silchar, dated 7/11/2023. Considering the above, the respondents therefore are directed to bring on record by a stand by filing the affidavit as to whether there are vacancies or not for consideration of the case of the petitioner for appointment on compassionate grounds. The affidavit be filed on or before the, let's have it on 28,
28 Lords.
28.
It will
Be filed on or before 22nd of January 2026.
be. Lords.
May I please, the Lordship?
Mm.
Your Lordship, the peruse the last order dated 3/12/2025, my lord.
Mm. This is on the question of jurisdiction.
Yes, my lord.
Okay.
My lord, the impugn order against which the petitioner has filed representation, Annexure 8 and Annexure 9. Those impugn order has been served to the petitioner in his place of residence at Dhemati under the jurisdiction of this honorable court. And against that, from Dhemati, my lord, he has submitted a representation at Annexure 10, my lord, page 147, from his place of residence at Dhemati. And I would like to rely on one judgment passed by the Honorable Supreme Court, my lord, which says that, my lord, because the impugn order of termination has been served on the petitioner at his place of residence under the jurisdiction of this Honorable Court. So, my lord, accordingly, the part of cause of action arises within the jurisdiction of this Honorable Court, my lord. Your Lordship may peruse paragraph 20, my lord.
Now, what are you challenging here?
Annexure 8, page 119, the termination order, my lord.
100 and?
119, my lord. The long order operating posted at page 143, my lord.
Where were you working?
In BSF, my lord. Initially, he was posted at under the at Rani BSF transit center, my lord. Subsequently, he was posted and subsequently, when he was in the state of West Bengal, my lord, he was terminated from service, my lord.
So you have been terminated.
Yes, my lord.
Now what remains out here?
My lord, against the termination, I have filed a representation at page 147. That has not been considered. So at this stage, my limited prayer is to consideration of my representation at page 147, Annexure 10, my lord.
22nd of October 2024.
Yes, my lord. 22nd of October 2024, that is Annexure 8, and subsequently another order, 26th of October, Annexure 9, my lord.
What is this?
Second of-
Committing a civil offense that used to say criminal misconduct by public servant Iman? The month of Iman was not itself neglecting duty, suffer imprisonment. Accordingly, the division of trial has been conducted, whereas the court has been. Against that, there is no appeal.
Yes, my lord. It is under, there is a provision under section 117(2) of the BSF Act, my lord.
Then
That is also rejected.
No, that is not rejected. That is the appeal at Annexure 10, page 1.
Anyway, Lordship may kindly peruse these two orders, Lordship. Supreme Court order, Lordship. Merely because the fax message has been received or the letter has been received does not give rights to cause of action, Lordship. In ONGC case, Lordship, paragraph 8.
No. These are different cases. These are not service matters. This is a different case. These are ONGC and Kusum Ignots are different. Kusum Ignots is on a different aspect.
Merely because the fax
ONGC
notice has been.
ONGC, these are all contractual matters.
Anyway, Lordship may kindly peruse 12 of the, paragraph 12 of the ONGC judgment, Lordship.
What does he say?
That quote from the Aligarh Muslim University, may I read that part, Lordship?
Huh?
In paragraph 12,
Okay.
the quote.
Yes, pointing out that
We-
after.
We are supposed, we are surprised not a little that the High Court of Calcutta should have exercised
Like, my lord.
Yes, why you're not considering this?
Lordship isn't filed in March, we'll consider it. Any case, we'll consider it, Lord.
You consider this matter over, what is there? We direct you to consider it. I'm not asking how you consider it, that is your lookout. Treat this as as an appeal under 117(2) and decide it in accordance with law. Huh? I think that is a better option. Whatever may be here. At the outset, it is relevant to take note of that in terms with what is that section?
Section 117, 1 and 2. Reconfirmation 117. 117, 1 of DSFL. DSFL.
At the outset, it is relevant to take note of that section 117 of the Border Security Force Act 1968, for short, the Act of 1968, provide remedies against orders, finding or sentences of the Security Force Court. In the backdrop, it is relevant to take note of that the petitioner herein where is the appointment letter?
My lord, call letter is at page 35, my lord. 35, my lord. Selected for appointment as so and so.
Was appointed as CT. CT means constable.
Yes, my lord. Constable. Constable.
As CT bracket GD in the Border Security Forces. In the year 1999. And was at the outset, it is relevant to take note of that the petitioner herein is a permanent resident of the district of Dhemaji, Assam, and pursuant to a recruitment process initiated at Dhemaji on 13/11/1998, The petitioner was appointed as a constable, CONST, GD. And the petitioner joined in the headquarters sector border security force at Rani Azara, Guwahati, Assam. Now tell me one thing, what is 117.1? Page 88 is what?
Page 88 is petition under 117(1), my lord.
What is that?
My lord,
Any person subject to this act
yes, my lord.
who considers himself aggrieved by any order passed by any security force court
Yes, my lord.
may present a petition to the officer or authority empowered to confirm any finding or sentence of such security and the conformity may make such steps as may be considered necessary. So this is to the confirming authority.
Yes.
Any person too subject to this act who considers himself aggrieved by finding or sentenced by any security which has been confirmed may present a petition. So this is the second appeal.
Second, the confirmation order is Annexer 8 and Annexer 9, my lord.
Oh, we'll have again come back
Yes.
to. And you kindly give the dates. It is very difficult. Your list of dates is horrendous. We impose a cost upon you. Okay. List of dates is what? What type of list of dates is this?
First sentence was on 1/11/2023. Against that, the petitioner filed a petition.
You gave 6 lists of dates. 31/3/99, 26/3/23.
Yes, my lord.
When did the proceedings start?
That is, my lord, the petitioner submitted 26/10/2023. Petitioner submitted his written statement.
What is the proceedings?
Yes, my lord.
Where is your charge?
My lord, I'm sorry to say, my lord, from the petitioner, my lord, he doesn't have available the search memo, my lord. I could not collect, my lord. Because the lots of documents, my lord, he also lost somewhere, my lord, during, because.
Are you saying that in the pre-confirmation order or the confirmation order, initial orders, there is no mention anything as to how it started?
That is there, my lord.
Why there is no list of dates? We pass this order, impose a cost of 10,000 upon you. Let me come back. Keep your 10,000 ready in Google Pay.
My lord, he's a very poor person.
No, not on
No,
him.
no, I understand.
You are not poor.
No, my lord. he's a
For
very
you.
poor
No.
person. And
This what has happened is because of you. No, because of Mr. D.P. Bora, not because of that council. Not Rajiv Dwara.
Yes.
It is Mr. D.P. Bora.
he is a very poor person and I am representing him, my lord, on the special, my lord.
So therefore, you do it. So because are you making a submission that because he is a poor person, you have drafted the petition horrendously? Something like that. Something has to be. So you must have done it intentionally.
Many times I contacted him.
No, Mr. Bora, if the petition now, if all the pre-confirmation orders are looked into, they have provided various dates.
Yes.
And you should have been more better.
To obtain the search memo. Many times I contacted. He also tried, my lord, but from the documents he could.
By 2 o'clock, provide the proper list of dates, handwritten. You give it to me. Otherwise, I will take
Yes,
note of whom ignotes and dismiss on limitation. Yeah.
I provide. Two to nine required, one to reject.
Nikhil last thought. Stop. Subsequent thereto, the petitioner was posted at various places Mustafa. While performing duties as mess commanders officers at THQ Match Factory Baramulla, a charge sheet was served upon the petitioner charging him of total 5 numbers of charges. On 29/2023. The petitioner submitted his written statement. To the said charge sheet. The General Security Force Court passed a fact-finding inquiry, a fact-finding opinion, holding the petitioner
Lordship, it's a
guilty.
proceeding.
Huh?
It's a proceeding. The GSFC conduct a proceeding, Lordship.
Fact-finding, holding, inquiry,
It's called a proceeding, Lordship.
fact-finding proceedings, holding the petitioner to have a charge, holding the petitioner guilty in respect to the third, fourth, and the fifth charges by a report dated 1/11/2023. The petitioner, being aggrieved, filed an application under section 117(1) of the Act of 1968 before the confirming authority. The confirming authority, by an order dated 27/8/2024, by an order dated
Yes, madam, 27/8/2000.
22/10 to
No, madam.
22/10/2024,
No, madam, prior to that 27/8/2024, ordered for revision. My list of days after 6/11/2000.
it's okay. These are not necessary.
Yes, madam.
No. The fact-finding, the confirming authority, by an order dated 22/10/2024, rejected the application filed by the petitioner under section 117(1) of the Act of 1968. And thereupon, an order was passed on 26/10/2024, thereby dismissing the petitioner from service. The petitioner thereupon filed an application under section 117(2) before the respondent number 2 on 18/3/2025. The said application, however, have not yet been considered And it is under such circumstances the present petition has been filed. This court have heard the learned counsels appearing on behalf of the parties. And it is the opinion of this court that as there is an authority, and it is the opinion of this court that as various facts and opinion of this court that as the petitioner has approached the respondent number 2 by filing an application under section 117(2) of the Act of 1968, the said application ought to have been considered. First, considering the above, this court therefore disposes of the instant writ petition with a direction upon the respondent number 2 to consider the application filed by the petitioner under section 117
He has
bracket
not
2.
specifically mentioned in this lordship.
The
petition.
application filed on 18/3/2025, which can be said to be an application under section 117(2) of the Act of 1968, and dispose of the same within a period of 3 months from the date a certified copy is served upon the respondent number 2. Full stop. With the above, the instant petition stands disposed.
Without expressing anything on merit,
Yes, sir.
lordship.
It is made clear. Before parting with the record, this court, however, makes clear that this court have not entered into the merits as merits, and it shall be absolutely within the jurisdiction of the respondent number 2 to decide the said application filed under section 117 bracket 2 of the Act of 1968 in accordance with law.
May it please the lordship. My lord, petitioner, my lord, challenging the order dated 3/1/2025, my lord, page, my lord, 38.
What?
That is, my lord, selected, my lord, respondent number 7 is an Anganwadi worker, my lord.
Where are you challenging? Where is that order?
Order, my lord, that is in select list, my lord,
Where?
page 38.
What is your name?
My name is my
Eliza Bromo. So you got 43.
Respondent number, my lord, 7, my lord, she got 33.8%,
Eight.
my lord.
Okay.
And my lord, I have filed an RTI application, my lord.
Let us see the advertisement.
Page 22, my lord. No, my lord,
Page 22.
Age?
yes, my lord, page 22, my lord.
Are you an HS pass?
My lord, yes, my lord, I'm HS pass, and my lord, due to my financial condition, poor financial condition, I could not continue my degree courses, my lord.
Now, why it has happened?
My lord, they had, in their, select list, my lord, remarks has been stated that I am a student, but I am not pursuing my lord further studies, my lord. And my lord, RTI application, my lord, which I had filed, my lord, they have informed, my lord, that is page 35, my lord, kindly peruse page 35, my lord.
Now, he's a student barred.
In the advertisement, my lord, SS pass is needed, my lord, for the Anganwadi worker, my lord. Lordship, kindly peruse page 35, my lord. lordship got it, my lord.
Mhm.
Page
Page-
35, my lord.
Yes.
In page 35, my lord, that RTI I had applied, my lord, on 6/6/2025, and they have replied my RTI, my lord, and they have stated the selection was made as per the public petition submitted differently by 3 numbers of Gangura and AWC MC president and public under the North Dotama AWC area, my lord, for selection of respondent number 7, my lord.
Now appointment order.
Appointment got, he joined my lord on my lord.
Page
34, page 33, my lord, on 34/2025. He had joined me, respondent number 7.
Where is the appointment order?
It's not an
Appointment order, my lord, only that select list, my lord. That page 38. And after that, my lord, I had submitted my lord representation, page 41.
So today you have not challenged the select list. Now you are asking for staying the select list. Select list has no value today. It has been exhausted.
My lord, as he had already appointed, appointed my lord, but due to my lord, in my representation, page 41, my lord,
Well, madam, the problem is why the selection, you see your prayer. Select list has already been exhausted. The select list has no value.
my lord,
You have not challenged the appointment order. Tomorrow, once I file the issue notice, they will come up and say, petition cannot be maintained without the appointment order.
my lord, respondent number 7 was appointed through this selection list, my lord, this, my lord, page 38, my lord. And there was no appointment order as far my knowledge goes.
Without an appointment order, how will you join?
Yes,
How did you get the joining report?
joining report, my
You see, there is a office order number. You are saying not there, page 33. Kindly see reference.
yes, my lord.
Then, without challenging it, tomorrow they are going to raise that issue only.
And I will file an additional appeal. I will
By what?
that this my office order, my lord, the appointment order, my lord.
Then, as of now, to your case is no case. Unless you challenge this appointment order.
I will take it.
Where did you get this copy?
My lord, this, my lord,
If you could get hold of this copy, you could have got hold of this order, the order copy also.
don't get my lord, but
This is more private document than the order copy. You have a good case, but the case is, tomorrow your case will be dismissed on that ground. What to do?
lord, I will take adjournment, my lord, and next date, my lord, I will take instruction from my client, my lord.
Okay. Ms. So-and-so appearing on behalf of the petitioner submits that she have not been able to procure the order by which the respondent number 7 have been appointed. Stop. You are appearing for whom?
Worship 3, 3, 4, 5, and 6.
Mr. So-and-so who appears on behalf of the respondent number 3, 4, 5, and 6. shall produce a copy of the appointment order dated 23/4/2025, by which the respondent number 7 have been appointed as an Anganwadi worker at 58 number North Dotma Anganwadi Center. List the matter on 21/2026. We'll see later on. Letter for motion. You produce that document.
1 and 2.
Have not issued notice. We'll see later on.
Item 18.
Yes.
I'm the widow of one Raman Kumar. Lampi.
Huh?
I'm the widow of one Raman Kumar. He died on 1/1/2003, Lordship.
Ah.
And Lordship, in terms of an office memorandum that says 11/9/1998, I wanted a ex-gratia compensation of 5 lakhs rupees. Lordship. And Lordship, that prayer was rejected by the authorities. But subsequently, I approached this honorable court and there is a direction in my favor, Lordship. Now, that 5 lakhs I received, Lordship, but then they did not pay the interest upon that, Lordship.
What is this?
I am praying for the interest, Lordship.
Huh?
I am praying for the interest which has accumulated with effect from 2023 to 2023. Lordship. I received it on November 2023, Lordship.
Why, there was a direction to pay?
Yes, Lordship, that Lordship will find at page 61. The relevant portion Lordship will find at page 63.
Now, at that point of time, why didn't you ask for the interest earlier?
That was not done.
Then you can't raise this issue again.
But that,
Tomorrow, these 5 lakhs, another 5 lakhs. No, nothing doing. You may come up again. Your earlier writ petition was there.
it was there, Lordship.
Then, well, you got clever with another, you want interest on what basis? Where is the direction of interest?
Interest was not given, Lordship.
Then,
Lordship, my prayer was also not there. with
Then?
regard to that. But Lordship, similarly situated persons have got that.
so what? Similarly situated person getting it here. What do you say about order 2, rule 2?
Since there was
Order
a
2
delay
or
in
rule
their
2 of the
participation,
CPC?
there
You
was a-
are to have the entire relief sought for. You are the council. You pay it from your own pocket. It's your mistake. You didn't make the prayer. No, bad case.
Similarly situated persons got.
So what? This happened in 2023. In 2026, you become clever. Where is your representation asking for interest?
I approached the authorities, Lordship.
Where?
Said-
By verbally.
Presentation is not there, but.
Then, what is this?
That communication I received, Malak.
Ah,
No,
There is a statement made, Lordship, I approached them, Lordship. There is a
No.
Statement made at
Statement, forget about statement. So where is that there?
Lordship, I approached Lordship. But otherwise, Lordship, if they pay me ex gratia, Lordship, and the date was in 2003 itself, Lordship. Now,
So what?
Lordship, the Honorable Apex Court has also said that from the date, 1 month after the date of the date, upon the compensation, the interest is to be.
Where? Where does the apex court say?
Lordship. This is one case, Lordship. And herein also, Lordship, there is a similarly situated person, Lordship, the next the order, it's at page 66, Lordship, we find that, Lordship. Lordship will find it at paragraph 6, Lordship.
This is under the Act, Employees Compensation Act.
But then.
How does this have anything to do with this?
Lordship,
Mr. Sharma,
Lordship.
Employees Compensation Act, by virtue of that Act 483, it is automatic.
Facts are similar, Lordship, otherwise, because. he was-
No, you are claiming this ex gratia on the basis of some notification.
Yes, yes. Lordship.
Then, where is it mentioned that they will be entitled to interest? Show me. If that office memorandum says, then I can consider something. Very difficult.
Page 41, there is nothing, Lordship. which is
Well-
considered interest. But then, in case of similar.
No.
Lordship, will
That
find it
is-
still page 65 once, Lordship.
Go to Rajasthan High Court. Rajasthan High Court,
Yes,
na?
Lordship.
Punjab and Haryana. Go there.
There is another order, Lordship. Lordship will find that page.
Then go to Delhi High Court.
16,
They,
Lordship.
this jurisdiction can be also exercised
I know
in
that,
Delhi High
Lordship,
Court.
but
They are bound by that. I'm not bound by that.
I'm just referring and saying that, Lordship, I am interested to.
Bad case, bad case. No case. You have earlier filed a writ petition, you never sought for this, and now you are asking for.
She is working as a pioneer, so.
Huh?
She is working as a pioneer, grade D staff, Lordship, so.
She is working as a? What is that? Pioneer?
Yes, Lordship.
What is this pioneer business?
Lordship, she is a grade D staff, Lordship, so her knowledge with regard to this is a Lordship.
Great.
D,
So, you knew it.
Lordship,
You filed a writ petition. I would have understood this to be the first time. You knew it. Are you also grade D? Then you are the main counsel who have caused all the. You pay it from your pocket.
so I argued this case, Lordship.
Then it comes glazingly out here. Your name. You had a senior also. Then he also didn't know that to claim interest. Now,
Lordship,
bad case. So dismiss.
that Lordship.
Sorry, not a case for issuance of notice. This is the second time, no. Division bench may help you. Chalo. Heard Mr. MP Sharma, the learned counsel appearing on behalf of the petitioner. Mr. You are appearing?
Grant me one order,
For what?
so that I'll be able to produce one case, Lordship, of the.
I would have, why on earth have you produced this type of judgment before me?
Lordship. Sorry, Lordship,
Huh? As if this court doesn't know what is Employees Compensation Act. Is it befitting of Mr. Sharma for you, who is a seasoned counsel now, to produce a document, judgment of this, where Employees Provident Fund, Employees Compensation Act or Workmen's Compensation Act is the question?
Yeah.
It looks nice.
But it relates to that death compensation only, Lordship.
So what? Tomorrow Motor Vehicles Act judgments are you going to bring? Then tomorrow you'll say, okay, 171 Motor Vehicles Act also apply here. Tell me.
Sorry for that, Lordship.
But tomorrow also being MSME also grants 3 times. Section 16 will also apply here. Don't bring this type of judgments before me. The council, when do you want the dismissal? Thursday. Huh?
You, Lordship.
After BU. Okay, you want to enjoy the BU? Give some hope to this lady. Give it. At the request of the learned. Okay, 19th I won't be sitting, so I'll have it on 19th. Some kind judge may issue.
Any other day, after 19, Malad? I have
See.
some.
See?
Not on 19, Malad.
Chalo, I won't be sitting from 2nd of February. Right on 2nd. At the request of the council appearing on behalf of the petitioner, list the matter on 2nd of February.
19.
Participated in a recruitment process.
What?
held by the petitioner participated in a recruitment process held by the Staff Selection Commission for the post of Constable Jail In Central Armed Police Forces Lordship. He has already cleared the computer-based examination, PST and P, but he has been rejected by the Review Medical Board Lordship. On the ground that there is discolorization leukoderma over sac of penis at page 32. The rejection is at page 32. Lordship.
Constable,
Constable
Constable.
GD,
Central Police Force.
Yes,
Central Armed Police.
Now you appeared out there in that exam.
yes.
I participated, I have already cleared the CDD, computer-based examination, PST, critical standard test and PET. But I was rejected by the medical board lordship.
Where?
The rejection is at page 32 lordship.
Who has done it?
The Review Medical Board
Review
Lordship.
Medical board. First, he appeared before the DME lordship, detailed medical examination, wherein they have rejected him on the ground of penile vitiligo. There is discolorization on his shaft of the penis lordship. Lordship at page 32, number 1, reason for medical unfitness, penile vitiligo, is by detailed medical examination.
This is only review medical examination report has been annexed, Lordship, detailed medical examination report.
So reason for medical.
Now what do you want?
Lordship, thereafter, he has gone before the Guwahati Medical College. So, Lordship, there the registrar of Department of Dermatology and STD have said that the lesion is not suggestive of vitiligo or leukoderma. That your Lordship will find at page 34. There is a discolorization on the shaft of his penis, Lordship, but it is neither vitiligo nor leukoderma, Lordship.
This is done by which board?
Lordship, the rejection is done by the review medical board, Lordship. CRPF.
CRPF Silchar.
Lordship.
Okay, now what do you want?
Want
Now you want to give an expert opinion.
Lordship, I do not want to give an expert opinion.
Then what do you want?
I pray for a fresh medical board, Lordship,
By?
to be constituted, a direction to be given to them for constitution of a fresh medical board. Since there is a conflict, Lordship, conflict of opinion, Lordship.
Conflict of whose opinion?
Lordship, I do not have, the candidate do not have neither vitiligo nor leukoderma, Lordship. It is just this.
Understood. So conflict between whom?
Doctors of the medical board and the doctors of medical college of Guwahati Medical.
Guwahati Medical College. So that is it. So now therefore you want that this court should direct them.
Lordship.
Now, the order which has been passed by the learned coordinate bench goes to the extent of saying that these things we cannot decide out there. So the asking you to submit a representation with all medical documents, then they will look into it. But you cannot change the medical board.
Lordship.
What do you say, Ms. Dekha?
Lordship.
The medical board may re-examine it.
Already re-examined, and he was found suffering from, he has a vitiligo. Lordship.
Earlier one was what?
In the detailed medical board also, it was found vitiligo. as
It
per
has been
his-
rejected. How can we help it if they
Yes,
don't
Lordship,
have it?
already rejected on this ground.
So you want this court should appoint a medical board?
I'm only praying for a similar relief, Lordship, since the coordinate bench in a similar matter, Lordship, where there was a.
There was a fractured hand.
Yes.
Lordship. And the report he brought from the government medical college, there was no fracture in his figure to Lordship.
Lordship, the review medical board has also taken the opinion of the Silchar Medical College. It is mentioned, Lordship. Specialist opinion taken from SMCH Silchar. Report attached.
Where?
In a page
Page
32, Lordship.
32, Lordship.
51?
Discolorization of.
Page 32, Lordship, 2, brief of the review medical board examination and finding thereof. On examination, discoloration over shaft of,
Decision of the
Yes.
review will be final. No appeal will be entertained against the finding of the reviewer in review medical examination. Where is Silchar Medical College?
This one, Lordship, under the heading brief of review medical.
This goes on so and so specialist opinion taken from SMCH Silchar.
Sir.
Both attached. Then,
Yes.
no, this court cannot exercise PPC.
For 1 minute to kindly see one thing, Lordship. Detailed medical examination, it was from penile vitiligo, Lordship. Silchar Medical College said it, they did not mention whether they said it is vitiligo or penile, leukoderma overstract of penis, Lordship. Lordship, let him file a representation, Lordship. The candidate will file a representation.
Have you filed a representation
No, I
with
did not
this?
file.
Why?
Lordship,
Lordship,
there is no.
Who has asked you not to file?
Lordship, there is no
Lordship,
appeal against.
appeal provision, there is no appeal
There is
provision.
no appeal provision,
No,
Lordship.
there is no appeal. Madam, kindly see the last line of page 32. Note.
Paste.
The note.
Yes. The decision of the review medical board will be final. No appeal will be entertained against the findings of the review medical board in review medical examination. Yes, Lordship, there is, appeal is not maintainable.
So therefore, he wants to submit a representation.
That's
Let him submit.
Lordship.
Go and submit. Who has asked you? If you are aggrieved by that, you want to submit with some medical documents, go and submit. And
And
what
also-
what is that? There is a one document which is attached. Where is the Silchar Medical College opinion?
It's not with me, Lordship, it is with them.
Report attached.
Report is not attached with this document, Lordship. This is just the rejection slip. They
Okay.
do not give us the report, Lordship.
Okay, we do one thing. We issue notice.
Lordship.
You don't file it. We issue notice. Ask them to bring on record that
Lordship.
opinion, and if that opinion is there by anything out there, then it is better.
Lordship.
Instead of getting from the register, because this type of what basis he has gone into and given this opinion.
Register of Department of Dermatology.
And
and
GMC also, Lordship, it is stated that the lesion is not suggestive of vitiligo. It is not a conclusive, Lordship. Apart
Oh,
from that,
it is not done. And what is the basis on which he has done it? Not known.
yes.
What
it
is the
on their
test which was carried out? What is the test which was carried out? As doctors, don't make it plural. Doctor. Issue notice making it returnable on. When can you file your affidavit, madam?
February 1st week, it may be.
Huh?
February 1st week, it may be.
Okay, issue notice making it returnable on 6th of February 2026. Ms. So-and-so accepts notice on behalf of the respondent numbers 1 to 5.
That's-
Extra copies of the writ petition be served upon her during the course of the day. The petitioner herein is aggrieved by the rejection by the opinion rendered by the Review Medical
Book.
Examination Board,
Ring.
GC CRPF Silchar, whereby the petitioner have been declared to be unfit. Full stop. The said opinion, so it has been enclosed at page 32 of the writ petition. This court had perused the said opinion, and it is also seen that there is also that the said opinion is also based upon a specialist opinion taken from SMCH Silchar. However, it has been submitted by the learned counsel appearing on behalf of the petitioner that the said specialist opinion have not been furnished to the petitioner. On the other hand, it is the case of the petitioner that the petitioner have also taken an opinion from the registered Department of Dermatology and STD, Guwahati Medical College, wherein it has been opined that the petitioner is physically fit to perform regular physical activities. Considering the above, this court directs the respondents to bring on record their stand by filing the affidavit on or before 4th of February 2026. In the said report, in the said affidavit, the respondents shall also bring on record the opinion, the specialist opinion, which was one of the basis on which the impugned opinion dated 15/11/2025 was based.
Post may be kept vacant for the, since the
No,
select list is
Lordship.
not yet prepared, Lordship. At least till that day. Till-
Okay, till the next date. Now, taking into consideration that the question as to whether the petitioner is physically fit or unfit is being looked into. It is being looked into by this court. On the basis of looked into, the respondent authorities shall keep one post vacant till the next.
Vitiligo is one of the condition for rejection of candidature, Lordship. It is in the, vitiligo is a condition for rejection of candidature. It is in the, there is a medical board.
Understood.
Yes.
I've understood. So therefore, I'm not asking to that he should be appointed. I'm only saying that one post should be kept vacant till the next date.
Or let's say subject to outcome, Lordship, instead of.
Focus notice was issued on 31/5/2024. The reference is of DP 9/2024. And while you are detailed a unit magazine of a guard duty on second paragraph 38/8/2024. And thereafter, so accordingly on 31st/8/2024, Sri Kiran Chandra Bora, SM of his unit has submitted a report along with your medical reports examined by the MNHO. Howley, where the report stated that you have found to have consumed alcohol recently and found positive of alcohol. So my lord, this is a predetermined, on the day they have initiated, they have issued me a show cause notice, they have already initiated this departmental proceedings. Which cannot be, my lord, that as per the rule line of Assam. My lord may see. And second flow is this, my lord, that if there are two inquiries that has been held, Departmental Proceedings 5 and Departmental Proceedings 9, in both the inquiry officer and the
What are you submitting?
my lord, at page 49, my lord, at the top, my lord may see the date, the 31/5/2024. The incident is of 38/2024. Assuming this show cause notice was issued on 31/8/2024, they are narrating an incident of 31/8/2024 in the show cause notice. And without my having my reply being served to them, they have started a departmental proceeding against me, my lord. The statement of allegations is there on the next page, and thereafter the order, my lord, the inquiry office.
Where is your statement of defense?
My lord, there is, my statement of defense has not been, but that is at page. My lord, my reply is at page 54. Most respectfully state that I am an employee under so and so. There on 23/4/2024, I consume alcohol with an earlier known person. As such, I have been suffering from nerve disease after consuming a little alcohol. I being senseless and as per direction of SM sir, I was medically examined at Kottayakal Primary Health Center, and as per of your honor 24/24/2004, I was taken back to the head office in the vehicle of force along with nursing staff and medical report. In the same way as per DP number 9 of.
What is the date of your reply?
Yes, my lord, that is the date of my reply, my lord.
What is the date of your reply?
This is the date of my reply.
What is the date of your reply?
30th It was 30th 12. My lord, it's on in the 55, in the
30/12.
30/12/2024, not 5 months. In Assamese translated. My lord.
Then
My lord, and now the second inferiority that I like to show, my lord, is this, that the DP was conducted, both the DP were conducted by same inquiry officer and same presentation officer, presenting officer. My lord may see page 51 and page 52, my lord.
so
My lord, the inquiry of DP number 5 of which is drawn up against you is completed. And accordingly, the inquiry officer Sri Nobo Kolita APS ESCOM of this unit submitted.
so you have been dismissed.
Dismissed, my lord.
Dismissed.
Yes, my lord. In fact, removal would also would have been at least eligible for me for getting pension. And my lord, in here, the medical reports strictly state that he smells of alcohol, but there is no test or there is no scientific test of whether I was under the whether on that day on the duty I was consuming alcohol.
But in your reply, you say that I was consuming alcohol because of my nerve problem.
Illiterate person.
Are you now saying that your English translation is wrong? Then,
It is there in the Assamese.
no, I'm asking you, is your English translation wrong?
No, I'm not. What I'm stating, my lord, is that whatever there is in vernacular, I have to translate as per as it is. But my lord, even then, even if the reply says a little alcohol, the department.
So how many years of service did you do?
My lord, from 2009 till 2004, my lord, at least
2000?
9 till 2024.
You'll get pension.
My lord, NPS, I will be getting the accumulated pension and the amount of thing that has been collected, my lord. 2009, not the OPS.
And if you are dismissed, you won't get.
So, my lord, what, and second thing is, my lord,
Well, we'll convert that. Don't worry.
my lord, it's a bias. It's and
What biased?
my lord, the biasness I can show, my lord, is this.
Mr. Sharma, first of all, you don't make arguments before me saying about 34 and 38. That also, I also know, you also know that was a silly mistake. Therefore, I wanted to see from your statement of defense, did you take that plea?
That what I'm suggesting is that, my lord, let us assume that this was on 30/8/2024. Well, even though if that was on 30/8.
This is not on 38/8, 31/8.
2024. In that, when the show cause notice was issued to me, there has been an incident that's prescribed on 31/8/2024. And as for the rule 9 of the Assam Disciplinary Service Appeal Rules, my lord, they should have waited for my reply and then started a disciplinary proceeding. What they have done, my lord, in reference, is DP 9 of 2024. My lord may see. So they have already predetermined that.
Rule 9 says about our inquiry first.
No, it says about the show cause notice first, and then again the reply, the inquiry would start. Here they have already determined that the department proceedings will be conducted. They did not wait.
Where is it? As per Rule 9, it is required?
My lord may see an order, my lord.
No. Tell me where in Rule 9 it is required that you have to be issued. They, Rule 9 only conceptualizes that they will be issuing a notice.
Yes.
And that wherein, more particularly, see Rule 9(2).
Yes. And definite charges on the basis of
So,
applications. Yes, my lord.
so this is what it is there. Where is the question of so? You are confusing. You must be doing a lot of central government matters.
I just communicate.
CCS matters where there is a question of show cause.
Even in rule 9,
Anyway,
my lord,
anyway,
without president.
anyways, it's a new year, so I will issue a notice here.
My lord. My lord, one more plea is there, my lord. I have given a representation also. I was suspended, I was reinstated back. And moment I was reinstated back, I had been working. And that time another second disciplinary proceeding started. And then the time I was working after reinstatement, they have not given my normal salary. And they have not even given me subsistence allowances. I gave a representation to them. Still now they have not given. So at least that may be released. I'm from a.
Detail after my answer, my lord. I will have to receive instruction, my lord.
Malot, he seriously, Malot, he was found, page 90, Lordship Kali say impute order, page 19, last page. 1, 2, 3, 4, after 4 lines, Malot. He was found under influence of alcohol for which he could
No,
not.
understood, Mr.
Yes.
Sudhir. These are all understood. But the question is, till you don't dismiss him, either on account of subsistence allowance or on account of salary, till when you have suspended him, it's okay. After suspension, subsistence allowance is entitled to. And prior to that, he's entitled to his salary. If he has not paid, you have to pay it.
Yes, Malot, after issuing notice, Malot, obtaining instruction, Malot, I record will say, Malot, what is happening actually. I know
No,
the
don't
Department of
worry,
Proceeding
not now,
number.
not now.
wo-
I'll pass an order to that effect. You verify if that any payment is payable prior to his dismissal
Yes.
and place it by way of an affidavit. And this is a case of dismissal, so we'll like to finish it off as soon as possible. File your affidavits and bring the records. Whether he's entitled, whether he's to enter, I don't know. We can convert it to removal,
No,
no?
no, that is the only, at least the person would not, he would have at least.
See,
enjoyed
Mr.
it.
Sharma has come down into from dismissal to just removal, not a reinstatement.
Sitting, reinstatement does not arise, because at least.
Anyway, issue notice. We'll finish it off on the next date. Issue notice returnable on 17th of February 2026. Mr. T.C. Sutia, the learned additional senior government advocate, accepts notice on behalf of respondent numbers 1 to 5. Extra copies of the petition be served upon him during the course of the day. The case of the petitioner herein have assailed the order of dismissal from service on the basis of two departmental proceedings initiated, being DP number 5/2024 and DP number 9/2024, which as per the petition is in complete violation to the mandate of Rule 9 of the Assam Discipline and Appeal Rules, Assam Services, bracket Discipline and Appeal, bracket, comma, bracket, Rules 1964. And also is in violation to the principles of natural justice. The petitioner also submits that till the date of dismissal, the petitioner is entitled to his dues, to his salary, and other dues. First, the respondents herein are directed to bring on record the stand by filing the affidavits on or before 6th of February 2026. Petitioner given the liberty to file any reply thereagainst on or before 16th of February 2026. On the next date, comma, an attempt shall be made to dispose of the writ petition, for which and accordingly, full stop, the respondents herein are also directed to place before this court the records of the disciplinary proceedings on the next date without fail. Mr. Shutia, kindly ask your people to file the affidavit as well as records. Otherwise, this court will assume that you have nothing to say. Yes.
I'm appearing on behalf of DCC Pukot. He is on leave. And his name is listed in the advocates on leave list.
Where is your file?
I don't have the file.
Hello? Hey, second copy to you. Yes, madam, what is the case?
The petitioner was dismissed from service, Lordship.
Missed.
Yes, Lordship. He was,
Because of a criminal case?
yes, Lordship.
Then,
At first he was convicted, but after that, a criminal appeal was filed by the petitioner, and the order of the order was the order of his was set aside, Lordship. Order dated 30/10, I think. That is on page. After that, he filed an
what is
representation.
201 IPC?
Zero two.
Chalo. We issue notice,
False information.
we issue notice.
Yes.
What is that, 201?
False information, Lordship.
False information.
Disappearance of evidence, Lordship.
Huh?
Disappearance of evidence, Lordship.
Or evidence.
Oh, yes, Lordship.
But it has been said to be, it is on the basis of the same evidence. Produce your records, issue notice. Issue notice, making it returnable on, we finish it off on 19th 2026. Ms. So-and-so accepts notice on behalf of the respondent numbers 1 to 4. Extra copies of the petition be served upon her during the course of the day. The petition herein is agreed by the impugned office order dated office orders number under memo number JTHA Duta ase dated 18/8/2025. Whereby the petitioner has been dismissed from service and thereby depriving the petitioner of all consequential benefits. It is the case of the petitioner that the petitioner was dismissed from service on the basis of a disciplinary proceedings based on the evidence which led to a criminal proceedings and the conviction of the petitioner in the said criminal proceedings. However, subsequently, the learned coordinate bench of this court by an order dated 21/5/2025 had set aside the judgment, had set aside the conviction of the petitioner and have acquitted the petitioner. Mainly on the ground that in the said criminal proceedings, the learned coordinate bench in the criminal appeal proceedings have not stated that the petitioner is entitled to the service benefits. The respondent authorities have deprived the petitioner of his benefits. It is under such circumstances that the petitioner has approached this court that challenging the impugned orders. The respondents are directed to bring on record their stand by filing the affidavits on or before 9th of February 2026. Liberty given to the petitioner to file reply on or before 17th of February 2026. The respondent shall also produce the records of the disciplinary proceedings on the basis of which disciplinary proceedings as well as the appellate proceedings on the basis of which the impugned orders have been passed so that an attempt can be made to dispose of the writ petition on the next date.
22
What is this?
Matter, my lord.
Huh?
Disciplinary proceeding matter, my lord. But the penalty of, major penalty of reduction of basic pay by 2 stages, my lord. Was imposed upon the petitioner. my lord.
Appeal file?
Appeal file, my lord.
Huh?
Appeal file, my lord.
Appeal dismissed.
Appeal dismissed.
Bank?
I'm appearing.
Bank?
Yes.
What is your charge?
Four number of charges, misappropriation of customer money, violation of bank's lending policy, as well as sanction and disbursement of loan without changing interest.
Two, it is by two, reduction of scale.
Yes.
Not urgent. You should notice making it returnable on 23rd of March 2026. Mr. A. Ganguly accepts notice on behalf of all the respondents. Extra copies of the writ petition be served upon him by tomorrow. The petitioner herein is aggrieved by the impugned order dated 7/12/2024, passed by the respondent number 2, as well as the affirming order dated 24/4/2024, passed by the respondent number 3, thereby inflicting major penalty of reduction of basic pay by 2 stages in the time scale for a period of 3 years with cumulative effect. Full stop. It is the case of the petitioner. What is your case? Or just filing it just for the sake of it?
No, the bank failed to produce any witnesses, my lord, but there's a violation of principle of nature justice, my lord. I was not allowed to cross-examine the documents.
Huh?
I was not allowed, given the opportunity to cross-examine in respect to the alleged documents, my lord.
Did you take it as a ground in appeal? Where is that? Appeal memo?
My lord, please 75.
Huh?
Please 75.
Where?
Page 75, that sort of management bank did not produce evidence of any witness.
Well, that final inquiry was held on only to cross-examine me by the Imam. You should have said that you are going to give adduce evidence. Not ground. What is your ground? No ground. Sympathy. Sympathy.
There's some other grounds also, my lord.
What are the?
My lord, they are alleging misappropriation of money, my lord. My lord, I have used this amount for settlement of KCC loans, my lord. I've never, my lord, used the money for my personal benefit, my lord.
It's a question of fact. How can I touch it?
There's some other grounds.
What are the grounds?
My lord, it relates to transferring an amount of rupees 5,000 from the debt.
Question of fact. I can't touch. Mr. V.K. Borua, appearing on behalf of the petitioner, submitted that the entire proceedings which have been initiated, the entire proceedings initiated by the violation of the principles of natural justice. And further to that, the findings so arrived at are perverse as it is based on no evidence. Taking into account the above, the respondents are directed to bring on record their stand by filing the affidavits on or before 9th of March 2026. Next date is 23rd, no? 9th of March 2026. Liberty given to the petitioner to submit reply on or before 19th of March 2026.
The award of marks so far as the private respondent is concerned is not in tune with the guideline of the department, Your Lordship. This honorable court was pleased to go for a press selection process, de novo process, Your Lordship, and Your Lordship will find the page 44, para 47 is the
As conducted by the
Direction
school
given by
selection
the
committee in
honorable
respect of the post of principal of the so remains satisfied. So it's granted its selection. So there is a fresh selection to be
press
conducted.
selection. The press selection, Your
There is
Lordship.
the office memorandum.
Lordship, then in the press selection, Your Lordship, my name was forwarded, Your Lordship,
Where?
by the authority. Then Your Lordship will kindly come to page 49. The impugn order.
This is the impugn order.
Yes, Your Lordship. In the impugn order, Your Lordship will find my name has been, Your Lordship, my marks have been reduced by 4 marks, Your Lordship. Although I was in the selection process, Your Lordship may kindly come to page 65 first, Your Lordship. After review selection, Your Lordship,
60?
65, last page of mine.
Ah,
Your Lordship will find that serial number 1, Gangadhar Burman, Your Lordship, I was awarded 17 marks. And then other two, Your Lordship, 16 and 16.
this is pursuant to the judgment passed by the coordinate bench.
And this was forwarded, Your Lordship.
Okay, then they
Then
reduce
what
1
is it?
mark.
Then they probably private respondent has come up with some complaint, Your Lordship, that has been discussed in page 49. Your Lordship may kindly allow me to read page 49, Your Lordship, the impugn order. Your Lordship. Read and peruse the speaking order number so that is issued by the Director Secondary Assam in compliance with the Honorable High Court order dated 6/9/2025 passed in WPC number 7 in case so and so filed by Sri Gangadhar Burman by respondent number 6. Jayanta Kumar Burman, he has present, by now he has retired, Your Lordship. Principal Council were reverted back to the post of graduate teacher with numbering Director of was directed to initiate necessary process to carry out the review selection among the candidates. So participating in persons to the advertisement issued in the month of October 2018 for the post of principal Belfast Higher Secondary School. Also read and peruse the hearing report of the State Selection Board held on 30/10/2025 in connection with Honorable High Court order dated 6/9/2024 passed in WPC number 776 of 2020 link is so and so. Filed by Gangadhar Burman. As per hearing report of the State Selection Board, it is found HSLC result of the Salmora HS School in the year 2017 is 16.2% and in the year 2018 is 84.61%. But the petitioners in Gangadhar Burman submitted record of HSLC result of Salmora HS School in the year 2017 as 94.73%, in 2018 as 90.
Now, what has happened as regards the departmental proceeding against you?
My lord, they have not initiated, they have initiated the departmental proceeding, my lord. Nothing has been done. No inquiry, nothing.
Meanwhile, he has retired. Your Lordship.
Who?
He.
You retired.
I have retired, man.
So you are joint of Burman.
Joint Burman.
So you are out now. You can't be promoted now. Now comes the other is.
He has already
Well,
retired.
if the-
Dehraduddin has also retired, Your Lordship. He has retired long back, Your Lordship.
So if he has retired, you are the only person.
Lords.
Then what happened?
No, Your Lordship, they have not appointed me, Your Lordship. They have not appointed me. I have to put this to challenge Your Lordship, since your Lordship, he was put above me, your Lordship.
Understood.
During the
But
service
these
period-
are, but they cannot be appointed now.
No, now cannot be.
Now where there is
will
no
get the
select
benefit.
list. Or is it required to have a fresh one?
That unless your Lordship appointment was made, your Lordship, there is no requirement. Had the Jayanta Burman be appointed in the meanwhile, your Lordship, and retired, there would have been no question of appointing him. But before your Lordship, this can be given effect to, he has retired, your Lordship.
But as per the AFRBM Act, there cannot be a select
No waiting-
list,
No waiting.
no
list.
waiting list. So they have not prepared a select list till now.
No, your Lordship, this is what they have passed, and after this, there is nothing. This into an order. It is,
Who is the appearing for a secondary education?
No one is there.
no one. Probably since this is your Lordship. Pans two matter, probably that is why they are not there.
Oh. The names have been shown.
Names have been shown, my lord.
Name SC education, SC education.
Let's have it on Friday.
Lordship.
The matter could not be taken up today, taking into account that none has appeared on behalf of the Secondary Education Department of the Government of Assam. None has appeared on behalf of the School Education Department of the Government of Assam. Under such circumstances, list this matter for motion again on 9th.
Lordship.
Full stop. It is observed that on the next date, if the Standing Council of the School Education Department is not present, orders will be passed in their absence. Caveat stands discharged.
For admission item 25,
There you have nothing. Do you have anything?
My lord, if,
Caveat is filed by you.
yes, my lord.
Do you have anything in respect to this?
My lord, if I get the benefit, my lord, I will get the benefit of a principal nationally, my lord. Retirement benefits I will get as a principal, my lord.
Recent
But
Supreme
as
Court
the,
judgment
as
goes
the
against
selection,
that.
selection has been made, my lord, during my service tenure, my lord.
But unless there is an appointment order, can there be an
Earlier I
appointment?
was
Unless
appointed.
you are a writ petitioner. Problem is you have to be also a writ petitioner somewhere.
My lord, I have filed a writ petition, my lord.
You have filed.
Yes, my lord.
Okay, then it's okay.
So lordship will take this writ petition along with that writ petition, my lord, in that case, my lord. The writ petition I have filed.
Mr. So-and-so who represents the respondent number,
Five. Six, your Lordship.
respondent number 6/caveator,
My lord.
submits there is another analogous writ petition being WPC number
6724 of 2025.
to list the said writ petition along with the present writ petition on the next.
Oblige.
What is this?
Hearing your Lordship, they can file an affidavit in opposition. But I want to make my counter, your Lordship.
What?
I want to file my counter, your Lordship, since the respondents have already filed the affidavit in opposition. But the
Were you sleeping for last
no.
7-8 years?
Herein the problem is that, your Lordship, I have no any, on several occasion I may try to contract with my client, your Lordship.
Mr. Dullo, what is the matter about?
My lord, he has given a false certificate then for matriculation and giving a false date, and he was appointed temporarily on probation, or on the verification found that he has given a false certificate and he was terminated, my lord.
Okay.
And as per during the probation, my lord, with a notice period with the payment that can be terminated. So it's a
So-
clear-cut case, my lord.
Okay, we then finish it off on another date. You produce the records?
Yes.
Okay.
I,
In the first week of February, my lord.
Yes.
I want to file my affidavit, your Lordship, because in absence of affidavit, I think.
For 8 years, you have not been able to. You have not been able to trace out the petitioner. Now you are going to trace out.
Only your lordship has last.
Anyways, you want to file your reply in the meantime. The instant writ petition is of the year 2017. And the affidavit in opposition has been filed on 24/11/2017. Taking into account that it is an old pending matter, list this matter on
3rd of February, my lord, if it is convenient, your lords. As you wish, my lord, February month, no issues.
let's have it on 17th.
Yes.
On 17th of February 2026. On which date an attempt shall be made to dispose of the writ petition. A final liberty is given to the petitioner to file any reply on or before 10th of February 2026. Mr. Doloy, the learned counsel who represents the respondents shall also ensure that the records of the disciplinary proceedings of the proceedings which led to the dismissal of the petitioner, termination or dismissal?
Yes, termination, my lord.
Termination of the petitioner are made available.
Yes, obliged.
So many old matters.
In this case also, I am handicapped, my lord, because the respondent filed the affidavit in opposition in 2018, and the petitioner absent and disconnected with me since 2019 till today. In between, I have posted some letters also, and one phone number is also available with me. That is also not responsive. In that case, my lord, I am handicapped to argue this matter whether the petitioner is alive or not, and no any other family members concerned also with me.
He was dismissed.
My lord,
Petitioner was dismissed.
my lord,
What is the penalty?
penalty suspension, termination, my lord,
So it's terminated.
termination.
Charge sheet and all. Look into it. We'll look into on the basis of the records, nothing more. The instant writ petition is of the year 2017. And the affidavit in opposition has also been filed by the respondents as far back as on 11/1/2018. No reply thereagainst has been filed for the last 7 years. Accordingly, this court fixes this matter for final disposal on 19th of March, on 19th of February 2026. Mr. V.K. Borua, the learned counsel who represents the respondents, shall ensure that the records which led to the termination of the petitioner are available on the next date.
My lord, 24th February.
You argue on this, ask anybody.
And
No.
10th of February, my lord.
My goodness, such old matters. What is this? Petitioner is serving as a medical health and officer for 12 years under the establishment. After completion of 7 years, he got chance to further study postgraduate in so and so environment. For the beginning of further illness, he was
Both. What is more qualified? 27 or 27?
Whatever. Have you accepted his resignation letter or not?
Lordship may kindly peruse the order dated 18/9/24.
As
It-
per order dated 18/9/24,
Petitioner is ready and willing. to
petitioner
pay
is,
an amount of
petitioner
25
is filed an affidavit, Lordship, stating that
submits the
he is ready to
given
pay the
time
amount.
one to make the above payment. Because he now required to place on record the above undertaking by way of filing an affidavit. What is this matter about?
The bond agreement, Lordship.
What?
Yes, Lordship.
What bond?
PG,
Is he still working?
no, Lordship. That is why he have to return the amount, Lordship. That's bond money. And he has filed an affidavit, Lordship.
Huh?
He has filed an affidavit, Lordship. Petitioner has filed an affidavit that he will pay the amount of rupees so and so on or before 19/12/24, Lordship.
He has
As
not
per order dated 18/9/24.
Huh.
The affidavit is whether it is there or not.
Has he paid that?
That is Lordship Petitioner Counsel to be present here. If in the affidavit he has,
No, you will be knowing it.
that I don't know, Lordship.
Huh? What?
That instruction, Lordship, I have,
Now, I'm ready to pay an amount of Iman on or before 19, which
yes,
is
whether he
reflected in
has
High Court order.
paid or not, that is,
Obtain your instructions and get it done,
Lordship,
finished off. When can you get it instructed?
within a week, Lordship. Fix it after the Bihu vacation, Lordship.
Okay, list this matter on 21/1/2026.
Lordship.
Ms. D.S. New,
Yes,
your name?
my name is Dee Bora.
So and so, appearing on
The
behalf
Health
of the
Department.
Health and Family Welfare Department, shall obtain instructions as to whether the petitioner had deposited the amount of rupees 25 lakhs as stated in the affidavit filed by the petitioner on 23/9/2024.
Lordship.
So on the next date, the council shall also obtain instruction, the standing council also obtain instruction as to whether the petitioner's resignation letter has been accepted. What is this?
Better election, Lordship, compassionate appointment, Lordship. Actually, this is a second round of litigation, Lordship. Lordship, the earlier order is at phase, Lordship, 17th.
When did your father and mother die?
Father died, Lordship, on 17 July 2003, Lordship.
2003.
2003, Lordship. Lordship.
And now you are,
I am 45 now, Lordship.
what do you want now?
Lordship, I have no other alternatives, Lordship, and due to the fault of the state respondent, Lordship, I have been deprived of my
Paragraph 35.
legitimate claim, Lordship. Lordship, will Lordship, kindly come to the page number 15. Though my application was under the ambit of 5% quota, Lordship, it was not recommended by the DLC, Lordship. At that time, Lordship, and thereafter I approached this honorable court, Lordship, and the honorable court, Lordship, instructed me to file another one case application.
Judgment to this. No, I think this is a case for dismissal, no more.
Lordship, my case is recommended by the DLC, Lordship.
Paragraph 35.
So what? In
Paragraph
2003, somebody died and you have been surviving for the last 22 years. It makes no sense.
But the continuous.
Therefore, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. J.K. Goswami, who appears on behalf of the respondents, all the respondents. All the respondents?
No, Lordship, here I am appearing on behalf of SLC and DLC, Lordship.
Where SLC, DLC? There
Yes.
is no SLC, DLC.
2 and 4, Lords, 2 and 3, Lordship.
This is PWD.
Others, rest, Lordship, 1 and 3, Lordship. I am
One
on
is
behalf
chief
of,
secretary.
yes. I am on
Are
behalf
you
of,
appearing into this
One and
Tunimba
two.
Sonwal? Is this the same case?
no,
What
Lordship,
is the name of your petitioner?
Yes.
Petitioner?
Tinamani Sunwal, Lordship.
Tinamani.
Yes, Tinamani.
So here
One and
we have only 4 respondents.
Yes,
One is the chief secretary.
Yes.
2 is the public commissioner and secretary, public works department. 3 is the deputy commissioner. 4 is the executive engineer.
I am on behalf of 1 and 3, Lordship.
1 and 3. Appears on behalf of respondent numbers 1 and 3. None appears on behalf of the PWD department when the matter is called. The petitioner herein is aggrieved by the inaction on the part of the respondent authorities in not considering the case of the petitioner for compassionate appointment. Full stop. From the materials on record, it is seen that the petitioner father, late Gopal Sonowal, was a grade 4 employee who died in harness on 17/7/2003, leaving behind the petitioner, her mother, that is the wife of the deceased, and two younger sisters of the petitioner. Full stop. The petitioner initially applied in the year 2004 and thus on account of non-consideration, the petitioner had filed a writ application before this court, which was registered and numbered as WPC number 4455/2014. The said writ petition was disposed of with a direction to consider the case of the petitioner against the available vacancies. Full stop. Thereupon, on account of non-consideration, the petitioner has approached this court by filing the present writ petition. Full stop. It is no longer res intriga that appointment by compassion, that compassionate appointment is not a source of recruitment. Full stop. It's an exception to the provisions of Article 16 of the Constitution. The Supreme Court, in the case of State of West Bengal versus Debabrata Tiwari and others, reported in 2025 5 SCC 712, had categorically laid down that compassionate appointment is not a vested right which can be exercised at any time in future. It cannot also be claimed or offered after a lapse of time and after the crisis is over. Paragraph number 32 of the said judgment, paragraph 32 and 33 of the said judgment being relevant, is reproduced herein under. In the instant case, the petitioner have been able to survive, have been able to continue, have been able to continue with his life for the last 23 years, 22 years. It is the opinion of this court that this is not a fit case wherein directions can be issued for consideration of the case of the petition at this stage. Accordingly, this court doesn't find any merit in the instant writ petition. Writ petition accordingly is dismissed.
30.
What?
The engaged counsel of the petitioner, Mr. N.J. Gupta, is on duty here.
You are there? What is the case about? I'll find it out by myself.
The matter will be addressed today.
What remains in this case?
I missed the file, but second file he is.
Understood, but the petitioner was 59 years old then, 2018. She wants a promotion. What can be given?
Oh, 60 years
To
that
promote the petitioner to the cadre of
Age
commissioner
of
and secretary
retirement.
to the government of Assam,
what happened?
who will be retired on 31/10/2000 due to her superannuation and on completion of the required eligible experience under the rules with all consequential benefits. What? No case.
Into which department? Give me the file. Lord, affidavit is there, my lord. Commissioner Secretary Personnel Air Department affidavit is there, my lord. Response number 3. Paragraph 6 perhaps. Regardless of so state that action in its meeting dated 24/7/18 while considering the case of petitioner, promotion of the commission and secretary of GADA decided not to follow the provisions of the reservation. As per WPTC BTC debate. On paragraph 6, they have stated, my lord, personnel department. Decided not to follow the provisions of reservation as per WPTC BC department that are determined. Reservation should not exceed 22% in the cadre. Accordingly, providing reservation in a cadre 3 posts will exceed the prescribed limit of 22%. The Anwarul Haq SCS was promoted to the commissioner and secretary grade as per seniority.
What is the age of retirement?
60, my lord.
60.
60.
What remains? Today she is 65, but the question will appear as regards whether she will get retirement benefits if she becomes, because she was otherwise recommended.
My lord, they are not recommended, my lord, because
What?
so they are saying, my lord, that if it is, my lord, there is no reservation is there. The paragraph 6 says, my lord, as per WBTC, the department letter number 29
Mr.
2014.
Mr. Sutia, kindly come to page 40.
40.
The minutes of the meeting of the selection board. Enclosure to your affidavit.
Yeah, yes. Yes, my lord. Dated 29 December 2014.
24/7/2018. Your affidavit.
Yes. Yes, my lord.
See the next page, the paragraph 5.
After thread-based discussion and perusal of SCR's dossiers, DP position, submission of the immovable property return, etc., and on consideration of merit with due regard to the seniority of the officer, the board, as per the provision of Rule 12 of Assam Civil Service 98, unanimously decided to recommend the following SS officers in the order of preference for promotion to the commissioner and secretary grade. He was promoted, my lord. He is promoted, paragraph 6.
Not recommended. Not promoted. It was recommended.
Decided to recommend the following officers. Officer of preference for promotion to the.
Now the question is as to whether there was roster vacancies available or not. There is no answer. That is the issue. Who is appearing for the government? Only you.
I said P. Nayak maybe, my lord.
Huh?
P. Nayak will be APS.
He is not there.
He's not there today, my lord. He told me, my lord, he's out of station.
Then?
But the next day, maybe if he's Friday, not, my lord.
Personnel department, government department, yeah. The whole matter,
Oh, old matter, my lord.
it is seen that the pleadings are duly complete.
But he was promoted, my lord.
Who?
Anwarul Haq.
Understood, but the
He's a
question
retired
is out here,
Yes, yes. my lord.
the
Oh, sorry, sorry.
grievance of the petitioner is that
Does-
she being an SC, she should have got a post. But that would depend upon a roster vacancy.
But they say the personal department, they cannot be exceeded 22%.
Ah.
That's why, my lord, her case was not.
So
considered.
22%, but the question is if there is on merit, if an SC is on merit, then what happens? Anyways, the instant writ petition is an old pending writ petition. And the pleadings are duly complete. So considering the above, it is the opinion of this court that the writ petition requires an early disposal. Accordingly, list this matter on 27/1/2026, on which date an attempt shall be made to dispose of the writ petition. What?
Oh.
You know,
Fixing the matter, madam. I'm just fixing the matter on some other date, madam.
27.
but this is not done. One has to be ready with your matters. No? This is not done.
Everywhere concurs. About to one hour, old woman,
This person, she has now become 65 or 66. If you don't complete it now, when will you get it? Yes,
My family pension claim, ma'am.
family pension.
Family pension. ma'am.
Why?
Only reason, my lord, appears to be my inability to submit the decree of divorce between my husband and his first wife. My lord, this is government employee, he married twice. I am his second wife. He married me after his first marriage was dissolved by decree of divorce by competent court. It is the admitted case of the government that I am the legally wedded wife. Now they are insisting for a decree. My difficulty is that I applied for the decree and I was informed that the connected record has been misplaced. And because of this, they cannot furnish the decree. Judgment.
You have
is
the
before
number? You have the order?
Yes, it is part of the record.
Where?
Page 29, madam.
Which court?
Family court member, Kamrup.
We do one thing. You want a copy of you are not satisfied with the final order.
Lordship, not Lordship, pension paper was forwarded, Lordship, but due to some want of some document, Lordship, we have returned, Lordship, and accordingly today also I have received the instruction, Lordship, pension paper is yet to receive to the office of the accountant, then, Lordship. So
When did your
administrative
husband die?
department,
The problem is that, madam.
When did your husband die?
Right, Lord. 20th of May 2020.
5 years.
The documents were submitted to the office. Office forwarded to the office of the AG. AG returned back soliciting some more compliance.
What
And
are the complaints?
Was one of the compliance is that decree.
It's okay. What are the other complaints?
Other was, my lord, can you come to their affidavit, my lord? Of R6. Can you take out the affidavit of R6?
Yes.
And para 6.
If relevant para 6, Lordship. They have not submitted the Lordship a degree of divorce, Lordship. That was asked by the AG, Lordship.
NOK, you have it.
Yes.
In a several correspondence will made with Aparna, the PAN card of AI has already been resubmitted for submission here, but she has not submitted certified copy of the decree of divorce to this office for which the respondent could not resubmit the year. That is the only reason.
That is the only reason.
Well, we do one thing. We direct the family court to produce a provide us a degree of. We have applied. They have lost the record on the basis of the
Yes.
particular material.
Yes, yes.
You have a certified copy of the death
No, that is not. Certified copy
of the judgment.
that is the kind of page.
You have a certified copy of the judgment or not?
No, no,
You have a photocopy of the judgment.
I'm the photocopy. I'm just check it now.
No, your client may be having.
Yes, yes. I will check. I will check up, my lord.
Okay.
I will check up.
This order was passed on 5/6/2026.
Yes. They are
Yeah.
saying, they are citing any reason why. and
Lordship,
degree.
that page 35 of the petition, Lordship.
We will not give any added sanctity to this order.
Yes.
Paragraph C, Lordship.
Why decree?
Para?
Paragraph C, Lordship, clause C, Lordship. Page 35, Annexure F.
Now, whatever may be, you see, this Roman Talukdar had a daughter,
Of the first man.
first marriage, but she continues to be a beneficiary of the family pension.
But as per the rules, madam, his wife have primacy over over this family pension claim.
But now the NOK contains whose name?
The second wife and the
Daughter.
daughter of the first. Page 39 is the NOP.
So next of kin is already done.
Everything done except this decree.
So we do one thing. We ask the registry to ask the family court to get a decree. Or we pass an order asking you to produce that certified copy and asking the family court to produce a decree, to give you a copy of the decree. Once that is being done, if they say that it is not possible to inform this court, if they say it is not possible, then we will treat this to be a decree. And on the basis of that, we may direct the authority to make on the basis of the certified copy of this
Without insisting for the decree.
without.
Insisting for the decree. I have to process my claim without insisting for a decree. If the decree is.
No,
not
no, we
available-
can very well ask the family court to prepare a decree on the basis, if they don't have the records, on the basis of this copy. You must be having a certified copy, I suppose. Because you have put it as certified to be true, means obviously you must be having the certified copy. I think that is the better way out, yeah?
Because otherwise, they did not cite.
No,
any
no, no,
reason
no, don't
why
worry.
decree.
Well, family pension, I understand, this needs to be done as well. First,
So family pension claim.
the petitioner herein is aggrieved by the inaction on the part of the respondent authorities in formulate in finalizing the family pension. and the delay caused thereof. This court finds it very pertinent to take note of the reasons which were assigned in the order dated 29, in the communication dated 29/2021. And further, the affidavit so filed by the respondent number 6, and more particularly at paragraph number 6. From the said communication dated 29/2021, and paragraph number 6 of the affidavit filed by the respondent number 6, it therefore appears that only on the ground that the petitioner have not been able to provide the decree of divorce in FC Civil 395/05 dated 5/6/2006, the family pension of the petitioner, family pension to which the petitioner along with the daughter, along with one Ankita Talukdar, is entitled to, have been stalled. This court accordingly fixes the incident with petition again on, let me come back, on 16th of February 2026. In the meantime, this court directs the principal judge, family court, Kamrup Metro at Guwahati to provide a certified copy of the decree of case number FC Civil 395/05 upon production of a certified copy of the present order. If it is not, it is further observed that in the circumstance, the said decree, a certified copy of the decree is not furnished to the petitioner, the reasons therefore be assigned by the learned principal judge, family court, Kamrup Metro at Guwahati before this court through the registrar judicial of this court.
There's some time, matter we fix on some other day, matter we dispose of it. For final here.
Oh, we'll be sitting in, we'll have it on 21st of February, Saturday.
Because the lady is not getting any financial benefit also after her husband's death. Long.
Chalo, let's try to do it on 29th of January. Let's try at 2 p.m. We'll finish it. So, taking into account that the petitioner have not been getting certain financial benefits and a request has been made, and a submission has been made that the matter requires an urgent disposal. List this matter on 29/1/2026 at 2 p.m. for final disposal.
Okay.
Yes.
There is no bar when a criminal trial is pending against a government servant, which is under suspension, to carry on a disciplinary proceeding. But the disciplinary proceeding will have to be conducted by giving opportunities and minor examining witnesses. There is a case, only the IO investigating officer of the trial case, trial is going on, it is at the faggot. He comes before the disciplinary authority, submits the charge sheet, and in verbatim, the charge sheet is reproduced. I was not allowed to examine him, cross-examine him, no witness, no complainant, and the inquiry officer found me guilty. And he passes the inquiry report, that's when I approach this court. This court, Mr. Lordship may have a look and page 15/5/2024 first. First one. Summarizing. That's how the inquiry disciplinary proceeding remain state. And there is a second limb of prayer.
No, one thing, Mr. Borba, tell me. When an inquiry report is given, you are asked to show cause? You must be given an opportunity to show cause. Then why should we stall anything?
In the manner in which the inquiry was,
So then
inquiry was done.
let the disciplinary authority take a decision on that.
Out the charge. Charge is, my lord, that I was arrested in connection with a case. And mere arrest, my lord, does not constitute the offense of misconduct. Tomorrow I may be supposed, I am found guilty, I am out of service. Suppose I am acquitted, then what? So mere arrest cannot be a charge by itself. That was another limb of my argument. Now, second limb was, they were not.
So therefore you are challenging the disciplinary proceedings.
Disciplinary proceeding. And that's how the court stated. Now there are certain developments. I was also routinely, my lord, there is a procedure for reviewing suspension. All right, when I was arrested, initial detention, 48 hours, necessarily I am suspended. That's the law. And then, my lord, I went out on bail. Continued, my lord, continued. Trial is on the other hand going on. And they started this disciplinary proceeding in the manner I said. So that is not done, that is not allowed, that is not.
No, suspension question has gone out because you have already retired.
I have retired out.
You have
Meanwhile, I have
retired.
and
You retired on 31/10.
very recently, I have been paid my provisional pension. Now I am showing you a latest order of the Supreme Court in such type of cases. Paul Anthony, I have read the record. It is not advisable to go ahead with, because I will be prejudiced. If before disciplinary proceeding, I cross-examine the IO, and then again at the trial, I cross-examine, I will be prejudiced, as your lordship knows that. There wait. Now, the latest.
But your disciplinary proceeding inquiry is over.
And there it is stopped. There it is stopped. Why? In such a case, that Paul Anthony says it is desirable to study departmental proceeding till conclusion of the criminal trial when the charge is same, dicto. Yes.
But then there is another judgment,
Yes,
subsequent
one of the
judgments have come in.
That your lordship, Giri. No. Here multiple accused. In my case, I was the only accused. Departmental, my lord, this is 2014, 3 SCC. Here, my lord, departmental conclusion of department inspector, very same incident. Number of accused, all were government servant. Lordship may now come to page paragraph 16 and 17. And then 19. Sufficient to, 16 I am reading. Suffice to say, that when there is no legal bar holding disciplinary proceeding and criminal simultaneously, stay of disciplinary proceeding may be an advisable course in cases where criminal charge against the employee is grave and continuance of disciplinary proceeding is likely to prejudice their defense.
But after this also there is a judgment. Recent judgment.
Here, what the court did.
Now, here in this case of this Tenzin Council India Private Limited, that is here case, the court did not look into it because there are three courts who held that, okay, let it be stayed pending the criminal
Court
proceedings.
did, my lord, paragraph 19.
Ah,
Paragraph 19, my lord.
that is what I read it.
Yeah. Paragraph 19, court said, into circumstances and taking into consideration all aspects, below have exercised their discretion. Three courts below exercise their discretion in favor of staying ongoing disciplinary proceeding. We do not consider it fit to vacate the said order as said. Interest of justice would, in our opinion, be sufficiently served if we direct the court dealing with the criminal charges against the respondents to conclude the proceedings as expeditiously as possible, but in any case, within a period of 1 year from the date of this order. Suppose today your lordship passes an order, lordship may dispose.
That is the discretion, the exercise of power under 142,
Even that, even
which I don't have.
under plenary power also. In case, however, the trial is not completed, it again gives a rider. Not again, period of 1 year from the date of this order or judgment. Despite his steps which trial has been directed to take disciplinary proceeding initiated to the respondent shall be resumed and concluded by the inquiry officer concerned, the impugned order shall be, in that case, be stand vacated upon expiry of the period of 1 year from the date of the order. This is how your lordship may even today dispose of this. That's my. because
That is
inquiry
not,
officer,
but Mr.
proceeding
Barbara,
and-
that is not possible. That is not possible for the purpose out here that I can't exercise that power over the criminal courts today. Supreme Court can do because they are exercising 142 here. This is a power which the court can pass an order because as of now, I don't have the jurisdiction. My jurisdiction is within my roster. Today, I can't direct the criminal court to dispose of a matter on a particular thing. So therefore, the Supreme Court can very well do it. That is one. Secondly, the Supreme Court did not interfere with that because there were three courts who held it okay, let the stay remain, which is not the case. This is the first court.
No.
But Mr. Barbara, there is a subsequent judgment. Have you got it?
Recently, my lord, it has been reiterated that it can go simultaneously. And my lord, in Paul Anthony's case also, my lord, in point number 5, it has been said that if the criminal proceedings are not moving at a fast pace, the departmental proceedings again can resume. And that has been given. And this ground should have been raised at the show cause stage, my lord. Petitioner has participated in the whole departmental proceedings.
No, now it is at the second so-called stage.
Yes, ma'am.
Not at the first so-called stage, this is the second so-called stage. Obviously, that may be tomorrow, the disciplinary authority may look into it and find out that the inquiry has not been done properly. That is the reason which they are going to do it. And thereupon, if the disciplinary authority imposes punishment, you are always at free to come before us. So that is how it is. But to stop out here now, it would be difficult. Huh? Anyways, I would not do it
My lord,
first day only.
I challenge the very manner in which the disciplinary proceeding.
Understood. So therefore, let it be that it is still within the realm of the disciplinary authority. The inquiry officer may have made a mistake. The disciplinary authority may not accept it.
Yeah, they may remand it.
They may remand it. So therefore, when you are filing your second
may-
show cause reply, they may accept it also.
Except you punish me where my pension will be affected.
Absolutely. So in that case, you can very well file an appeal or file before us. But the fact remains that process has to proceed. If it was a case that at the nation stage out there, then there was a question of your defense being disclosed, then the question would have been different because the so-called proceeding, you have given your statement of defense.
Trial is not yet finished.
Here, in the disciplinary proceedings, the inquiry proceeding, you have already submitted your statement of defense. So, yes, obviously, yes.
Given, but only the IO was called. I have stated here.
No, it's okay. But these are questions which can be looked into at a later stage as to whether it is a perverse or not. But when the disciplinary authority is to look into it, then why should we now exercise the powers of judicial review?
Because my challenge remains. Why, my lord? Trial it, leave the trial at its where it is going. Lordship is not here. On the trial. When I challenge the disciplinary proceeding, for question of the disciplinary proceeding, that will come to judicial adjudication by your lordship, either this way or that way we have to do that. My submission.
Mr. Barbara, Mr. Barbara, if you are coming before this court and saying that to quash the the disciplinary proceeding, it has to be on the basis that no case under any circumstances is made out. We have to use the same 482 powers of quashing as it is. Yes, so it will be on the same parameter, but not on the basis of a defect in the inquiry.
Look at page 47. What is the type, very charge, my lord, they have level. Kindly have a look at 47. Arrest. 47 is my reply.
Yes,
There,
47.
charge is okay. Page 40.
Where is your show cause?
Page 40. Page
40.
40 is there, sir.
You are hereby required to show cause under rule 9 as to why penalties in the charge one that while.
You were
Posted
arrested
deputy
by the
superintendent,
crime branch.
right?
So this is the charge. Therefore, you are charged with misconduct. Arrest by itself doesn't amount to misconduct. That is my case. Next page, my lord, statement of allegation. Page 41. The basis of the proceeding is what? Arrest. Statement of allegation is what? On so-and-so date, so-and-so was arrested by crime branch. List of witness, only one. Officer in charge, crime branch. Can a disciplinary proceeding be founded on this very foundation? That is my precisely my why I approach this. And your lordship will definitely not refuse adjudication on this.
Yes, Mr. Botakur.
Final order has not been passed, my lord. So
Understood, but fact remain. This may be a case for suspension. This may be a case of suspension that you have been arrested behind there for 48 hours. But merely because there is a criminal case, can that be a case of penalty? Whether section 7, rule 7, all these 4 things will be attracted, unless you allege that you have been found to do this. And when these are happened, and this is unbecoming of a year, but merely because a case has been filed against somebody, or is it mentioned out here in the some appeal, discipline and appeal rules out here, anywhere, that if you are charged with an offense of moral turpitude, then obviously you can impose the punishment, a disciplinary proceedings can be initiated. If it can be, very good. Otherwise, no case. But I don't think these are the cases. 7, kindly see Mr. Barbara 7, rule 7. The 4 penalties, the 5 penalties, 7 penalties.
64 rules.
Yes, 64.
And nature of penalties, my lord, 64 sufficient.
7.
I think they are not in a position to impose any of these penalties. Kindly have a list of the punishment, right from censure to dismissal. I am already retired. Next, regard me below. I am superintendent, suspended as superintendent. That you cannot. Compulsory retirement. The question doesn't arise also. The recovery from pay. This is not a case, my lord, of recovery or my lord, misappropriation of money. This is not a case, my lord, which is related to my service. It is a different offense. Censure withholding.
Now, can he,
So ultimately,
can they terminate?
lordship,
Now, as you have retired, now once you retired by virtue of the some pension rules, the disciplinary proceedings automatically continues, which was earlier not there, but there was an amendment by which now it automatically continues. Now, once it continues, if there is an order of termination, would it not affect your pension?
my lord, rule 22 of the Assam pension. That is my lord mentioned in another order. When the matter came before another single judge matter, that order is your lordship, my lord.
No, it's okay. It's okay. Not on that. My question therefore is, can you maintain your on the basis of these allegations?
Yes.
Mr. Botakur,
Yes.
difficult. What is your allegation? And so was arrested at so and so under here. No. Merely arresting somebody, would it be a disciplinary proceedings.
That by itself.
Unless the law says that if you are arrested in respect to an offense involving moral turpitude or heinous offense, then very well. But that's not the law. Arrested would be a case of suspension at best. So, you need to finish it though, soon. No case.
Let
You'd
the
allow this.
final order be passed, my lord, then, my lord,
What final order?
because, my lord,
He's challenging the very edifice of the proceedings as to whether you can maintain your disciplinary proceedings on the basis of the charge sheet. The charges against him, you cannot, there are various judgments of the Supreme Court making it very clear out there that you have to go as per the charge. You can't deviate and find out he, this, that, or whatever may be. You can't find out all these aspects. So the charge is that he was arrested in respect to an offense.
because, my lord, in this departmental proceeding, my lord, the standard is preponderance of probabilities, my lord. We need not have a
Understood, Mr. Bhattakur, but are you not required to state the basic facts?
because in the discipline and service rules, my lord, grounds are not given, my lords. Only thing is we have to
Understood. So, can a person be arrested in an offense be a ground for disciplinary proceedings? Unless you say that these are the basis on which it has happened. There's no basis. Simply says that you have been arrested, it is unbecoming. Does it become unbecoming if you are arrested?
usually, my lord, in a because this case is a POXO case, my lord. So the disciplinary authority, my lord, thought it was to initiate a departmental proceeding. What happens, my lord, as a final order, my lord, that perhaps needs to be seen.
So I think you should fight out lot. Now, if you see another rule by which a person is convicted, then what happens? We'll have it on some other day, but you just find out if a person is convicted. Okay, these disciplinary proceedings is gone. But the problem is once these disciplinary proceedings are gone, if it is quashed, then you may not be able to reinstate or initiate a fresh disciplinary proceedings on the basis after retirement. Disciplinary proceedings which have been initiated can be continued, but you cannot initiate a fresh disciplinary proceedings after retirement. If I am not wrong, that is the law.
Yes, ma'am.
So therefore, if I quash this, it goes. But what happens if he's convicted then? So find out. You find out as to whether mainly on these allegations you can continue.
Can it be
There
sustained?
are many judgments you cannot continue. Yes, Mr. Barbara, what do you want now?
Yeah, that's it, man. The very foundation I have changed.
Chala. We have it some other day, not to finish off our disciplinary proceedings on the first day itself.
Father,
Huh?
father,
File I have not yet opened.
wait, never mind, my.
Any date, my lord.
I have.
No, because the only problem is that. Otherwise, if you can improve and say, there are many judgments to the effect, wherein he says that the charges have to be clear. Otherwise, it's a violation of principles of natural justice. On that basis, your charge sheet will go. Without the charge sheet, your disciplinary. The moment he challenges the charge sheet, I hope he has challenged it. I have not looked into the file. The moment he challenged the charge sheet, if the charge sheet goes, your disciplinary proceedings falls like a pack of cards. Okay. Heard Mr. S. A.C. Barbara, the learned senior counsel, assisted by Mr. M. Smith, learned counsel appearing on behalf of the petitioner, and Mr. I. Bhattakur, the learned standing counsel of the which department?
Excise department.
Excise department. Mostly. Mr. A.C. Korwa, the learned counsel submits that the very disciplinary proceedings so initiated is cannot be sustained in law. And as such, the said disciplinary proceedings is required to be quashed. The learned senior counsel further submits by drawing reference to the charge sheet that the allegation is merely that the petitioner was arrested in connection with a criminal offense, which under no stretch of imagination can be said to be a charge to withstand a disciplinary proceedings. Mr. Ibothaku, the learned counsel appearing on behalf of the petition respondents, however, seeks for some time in the matter. Taking into account the above, lists this matter on when? 17th February? 17 February 2026. Interim order partially shall continue till then.
May please Lordship, some time will be required to file affidavit Lordship. In item number 36 Lordship, instruction received Lordship.
Okay. You file affidavit?
Lordship. Both the
Petitioner not appearing.
not present.
None appears. We in this matter 3795. Who is appearing?
I am agreeing.
None appears for the petitioner on call earlier. Huh?
That will be 36 time appearing.
Not 30.
You are appearing for same name petitioner, two counsels.
Two petition. One petition.
And rule has been issued.
Two represent Lordship.
Huh?
Different cause of action.
Different cause.
Why both the matters are tagged together?
Oh, I think yes. Otherwise, my is should be listed for hearing as per the earlier order. 13th, there is an order.
This one. Yes. You have filed your affidavit with both matters?
No, Lordship. On I paying for item 36 Lordship.
What is the matter of 36?
36 is.
This is what happened. The petitioner was posted as a deputy director in 2007. He was arrested on 2009. Thereafter, he was suspended. Later, he was convicted by the trial court. And on appeal, he was acquitted. And initially, he was dismissed for conviction. But later, by a judgment, his dismissal was set aside. But liberty was given to continue his departmental proceedings and continue his suspension. Now, during suspension, his lien was shifted to a lower post. He was as deputy director, but he was lien was shifted to probation officer. And therefore, there by an interim order on 4/10/2024, in this case, the Honorable Court directed to continue the subsistence allowance as per the deputy director, but they have not complied with the order. I think there is a contempt pending also, which he is appearing.
Okay.
And
So-
my interim order was made absolute by 13/6, but there is no affidavit.
You are not going to file it.
Lordship, parawise
appear for
received,
whom?
parawise received Lordship.
Who appears for NC Hills?
Lordship.
NC Hills, who appears?
I am not Lordship.
Okay.
There is separate council Lordship.
Okay.
I am
Mr.
appearing.
So appearing on behalf of the respondent submits that the parawise comments have been received and the affidavit would be filed in 2 weeks' time. 2 weeks.
3 weeks Lordship.
3 weeks, then we'll see the face of that particular officer who has to file. Then we'll see. 2 weeks is 2 weeks. 2 weeks. List this matter again on 6th of February 2026. The affidavit be filed on or before 4th of February 2026. This is 36. Yes, none appears for the petitioner. What is this?
Item 35 Lordship, sometime will be required Lordship.
Right.
Instruction not received Lordship.
Suspension order and the extension.
which is made in by suspension order, that was not made in accordance with the orders of the judgment, within a period of 90 days.
You are suspended?
Yes, I am in suspension. But initially what had
Have you
happened first,
given him the charge sheet?
Lordship, that was not receive any instruction,
So,
Lordship.
it has
Lordship,
been-
3 weeks time, Lordship will obtain the whole instruction.
2024 matter, 2 years have gone and no instructions. Huh?
Instruction
Which-
received,
which
Lordship, sorry,
department?
Lordship.
Child welfare. Who has suspended him?
suspended pursuant to my arrest. in
Who has
proceedings.
suspended you?
Malad,
Who has suspended you?
by the Commissioner Secretary by the Government of Assam, Social Welfare Department.
Social welfare, you have not made them a party. Mr. Counsel, you don't know your brief.
Principal Secretary to the Government of Assam, Women and Child Development Department.
So?
Now, renamed as Child Development Department.
Social welfare has become
They
child
have
development.
Women and
Child.
for this.
Women and Child Department.
Huh?
Now it is Women and Child Department.
Okay, Women and Child Development
Develop-
Department. They have suspended you. When?
Suspended on 6/6/2009.
What?
Yes, madam.
2000?
2009.
Until now you have not completed.
No, but what happened in this case, but initially I was suspended due to my arrest in a Cochiti PS case. Subsequently, that case was taken up by the NIA and the trial was going on. I was inside the jail, madam. And the conviction has been made subsequently by the trial court. And after that, I have preferred an appeal before this honorable court. And this honorable court, madam, on 11/8/2023, set aside the trial court judgment. And thereafter, I have challenged in the meanwhile, madam, I was dismissed from service pursuant to my conviction. And I have challenged this by.
Then they reinstated you.
I have challenged before this honorable court by filing a writ petition challenging the dismissal order. Since my dismissal order was based on the conviction, madam. And then this honorable court has passed a judgment by which set aside the dismissal order, madam. Just taken up page 42, madam. Page 42. And the relevant portion, my lord, can you see page 55? The last paragraph.
Oh, this matter.
Yes, madam.
Hmm.
Then I have been, my
Impugn
dismissal
order of the is set aside, the petitioner will be taken back forthwith here. Now, after this direction,
after this direction, my lord, they are supposed to, given the charge memo, my lord. The charge memo has not been given and the extension was made by showing that they have made the extension on 5/5/2024. But in fact, the same has been received by me on 10/5. Okay.
it's okay then.
That has been challenged, madam, because the after 90 days, because direction. Direction.
Don't
was-
worry. I think this is a case for dismissal enough. Charge is given. After 90 days is not the question. They have given it, na? You see the paragraph 21 of the judgment in Ajay Chaudhary. And it is then?
But
Ah.
90 days has to be followed, my lord.
What 90 days? Let's see if there is a further line, the last line of paragraph 90. Where is the
Charge
judgment?
memo has not been given, my lord. The
Huh?
charge sheet has not been given. Charge sheet has not been given. Only the show cause notice has been issued.
So cause is the charge sheet.
But,
Assam discipline and appeal rules, where is it mentioned that there is a charge sheet? So cause. That is the charge sheet.
It was issued it was issued long back. Look, here, madam,
Okay.
some
21, my lord.
Paragraph 21.
Furthermore, the direction of this, we therefore direct that the currency of the suspension order should not be extended beyond 3 months. If within this period, the memorandum of charges or charge sheet is not served on the delinquent officer employee, if the memorandum of charge sheet is served, a reason order must be passed for the extension of the suspension. As in the case in hand, the government is free to transfer the person concerned to any department in any of its offices within or outside the state so as to sever any local or personal contact that he may have and which he may misuse for the obstructing the investigation against him. The government may also prohibit him from contacting any person or handling the records.
Then the next paragraph starting, first line.
First line, so far as the well, paragraph 20. so far as the facts of the present case are concerned, the appellant has now been served with a charge sheet.
And therefore we are
the
not.
direction may not be relevant to him any longer.
So, no case. I did these matters a long time back, so I remember a little bit on that. So, no case. So, what to do? Dismiss?
Let me taken up any other day.
So, when do you want the dismissal?
I leave your lordship.
Same day, along with you.
Same day, lordship. Let it be there.
The moment this goes, oh, he doesn't want with that. Okay. The list, Mr. So and so, I think we finish it on 9th. Before Bihu, we finish it up. List the matter on 9th. Not yours. Yours I fixed it some other day.
Regarding the 36 method, there is contempt also pending document.
Not necessary. Not necessary. Contempt you mention and then I'll take it up.
Lordship.
Lordship, in this case, I have received the record today only, so I need some time, Lordship. Lordship may fix the matter on 8 January, Lordship.
Urgence?
Yes.
Interim order is there, na? It's difficult. We have a division bench also.
After the Bihu vacation.
What is the interim order passed?
2012, 24. Half of them.
What is there? This is the case should be allowed. Rafiq Masih's case. Anganwadi is the health department in such a shape that they are going to take this 900 or 1200 rupees they are getting. Stop building bridges. Build some bridges with these people only. No case. I think petition should be allowed. I think paragraph number 22 or 23 of Rafiq Masih, na? ABC. This is the case.
If you have to recover, my lord.
Ah.
I have your lordship order, my lord.
Ah.
You can directed to recover the amount which they have collected, my lord.
How much is the amount?
Amount is, my lord, 43 lakhs.
Wait. Why 43 lakhs?
There was this overstay.
Overstay, Lordship.
Overstay of how? What did he do?
Overstay in service, my lord.
No, as what?
My lord, as an NMN.
ANM, Lord. She was an ANM, Lordship.
Auxiliary nurse midwife. ANM.
Auxiliary nurse wife.
Yes.
ANM.
I have filed the affidavit also, Lordship.
That's absolutely your problem. You have done the problem. 1/2/2017 to 31/3.
Yes.
Didn't you maintain a record book? Service book? Who maintained? There was a service book, I suppose.
Yes, Lordship.
I have given my service, my lord.
Yeah.
I have given my service also.
Get hold of all. This is the service book.
Lordship, may kindly say my affidavit, Lordship, page 49, annexure 1. There is an overwritten 19 years, 1 month, 9 years, Lordship, 9 months, Lordship. That is why the Honorable Court has directed me to produce the record, Lordship.
And you have got the
So record I have received today. I have to go through it, Lordship. So that's why.
Chalo, on
I
8th
need
we
some
finish
time,
up.
Lordship.
No, on 8th we finish it off.
Yes, Lordship.
First off.
That is why.
First of
today's
all, we
amount.
should allow it. This is the matter on 8/1/2026.
Obliged.
An attempt shall be made to dispose of the will. Interim order passed earlier shall continue.
All right.
What is this? S. Bonik, what are you doing with this matter?
This has come with the valuation report.
He has come with a mediation report.
What mediation?
But although mediation was not even required,
What mediation is this?
but this is a case. May I submit? This is a case where the lady is in grave penury. What has happened? I am the second wife of a Mohammedan gentleman who died. The first wife was there.
First wife?
Was there alive, no divorce. I was second, no Mohammedan gentleman. After his demise, when I approached this court for pension, this court rightly held that second wife is not entitled after judgment of the Honorable Apex Court, although there are High Court judgments of this court, but he's not entitled. However, as the first wife conceded that she's ready to share an portion, therefore, this Honorable Court, although held that there was misconduct on my part, on my husband's part, yet it can be apportioned. Accordingly, we have to apply. All right. Now we went to a division bench. The judgment is there. It's there. I'm not referring you. Now we went to the Honorable Division Bench, and Honorable Division Bench says, no, there was no proceeding, so there can be misconduct. So that part be set aside, and both of you, since you agree to go there, the first wife also agrees, well, you go. Accordingly, pension was being apportioned between both. Now the mother comes, and mother says, mother-in-law comes rather, and says, please help me. I also need to be looked. Accordingly, this Honorable Court, by another Honorable Single Bench, says 40-40-10. 50-50, 40-40-10. This continues. Now the authorities issue orders at Annexure G and H, whereby some retired benefits are to be given only to the first wives. At this stage, we find the writ petition saying that it is on the face of the tyranny, exercise.
Why?
Because out of judgments which are
Go to civil court.
No, I'm not on that. That this Honorable Court has
No,
decided.
no, have you seen the full bench judgment? The full bench judgment on this issue. On that basis, the full bench judgment categorically, I think the Justice Saya, then Justice Soumitra Saikya and Justice Bujal Borua. All this, I think it is being offered by Justice Bujal Borua, wherein it says that it will go to the first wife, and then the
Yes.
first wife being the caretaker out there.
Yes,
He becomes the trustee.
Trustee.
She should have to deposit, and if they have any problem, go to the civil court.
Yes.
I'm that below.
Trustee.
Since this list concerns, this act was prior to that and taken note of, and the first wife agreed to apportion. And on that premise.
That was the family pension agreed, not this other retirement benefits.
Right.
Very well. So, go there.
So on the family pension now, my IAB, the IA is that my family pension.
Go there, go there. No
But there's a
case.
judgment of this.
We
Honorable Court.
cannot. It is a interstate dispute between you and the
Yes.
first wife.
It is not an interested dispute any further.
It
If
is.
I may just invite my note attention.
No. If you haven't looked into the full bench judgment.
Anwara Khatun, Lordship.
Huh?
Anwara Khatun.
See?
So what I am on for a moment, Lord, if Lordship takes up.
No, that case. First day, no dismissal. In that case, I can give you a good date. You may get a good order someday. Not me. First day is bad case. Give you dates, 19th January, 2nd to 13th February, any of these dates. Choose 2nd to 5th. List the matter on 4/1/2026. What is this? You're still under suspension.
Yes, sir. 1/10/2023. Yes, please.
No charge sheet?
My lord, question is, my lord, last occasion I was asked to obtain instruction whether departmental proceeding is completed or not. What is the status of departmental proceeding? Now the question of extension and review is not arise. This is not a pleaded case.
No, I'm asking you whether you have some, whether the disciplinary proceedings have initiated or not.
So cause is issued, my lord.
So cause issued.
Nine.
The parallel proceeding is started, but what is the position now, my lord, I cannot say. Sometime may be required.
Now, every 6 months, you are to review. Are you reviewing it?
That is true, but it is, in this repetition, that was not pleaded.
Not necessary. I'm asking you. It's
That is-
law.
That is true, but whether that has been done or not, I don't know. But
Find out. We have it on 9th. Before vacation, find out whether you have done it or not.
yes.
But this is a case of prolonged suspension. Full stop. The case, full stop. It has been submitted that the departmental proceedings have already been initiated. Full stop. However, the question arises as to whether there has been periodical review to the suspension. Mr. T.C. Sutia, the learned additional senior government advocate, shall obtain instructions in that regard. List this matter on 21/1/2026.
21, my lord. Well, the last review was 14/5/2024.
You just find out. What is it? Admission.
Obliged.
This letter is that the matter of petition is eligible procedure, by which matter the authority going to be make the appointments. Matter in this regard, the last occasion, the notice was issued, and notice was also issued in the interim pair matter. But in the meantime, my lord, on 22nd of December, my lord, they have made the appointment. But here, what happened, my lord, the post was.
What is this? For the post of technical assistant for CSS and technician for CSS. What is CSS?
Yes, meaning is not meaning that advertisement, my lord.
Petitioner was shortlisted for documents verification after qualifying, requiring it. Yes, have you filed affidavit on?
Lordship, I'll be receiving my instruction, Lordship. 2 weeks time may be granted, Lordship. I'll file my.
Hello, 2 weeks time. Mr. D. Upamanyu, the learned counsel submits that he has received the instructions.
Lordship, I have received telephonic, but within 2 weeks, Lordship, I'll file, Lordship.
Received the instructions and would be filing the affidavit within 2 weeks. Mr. D. Burua expresses urgency, taking into account that there is no interim order passed. Considering the above, list the matter on 28, 2 weeks, 28/1/2026. Full stop. The affidavit be filed on or before 27/1/2026. Full stop. On the next date, this court shall consider whether there is a requirement of any passing any interim directions.
Highly.
What happened?
Lordship, pursuant to the last order, we have deposited the amount of 23 lakhs via treasury challan. The communication was also done to the deputy commissioner. However, no further steps have been taken, your lordship, from the respondent.
No, my lord, it has been processed in the office of the co-district commissioner. Now there is a office of co-district commissioner. And from the office of the CDC, my lord, and communication has been made, my lord, day before yesterday, 2 days prior, asking the circle officer to do the needful for record
So,
correction.
Let us have it again on 31/2026 for an update.
For the timing, if lordship, my lord, they are doing it, my lord.
Give
They are
us
doing-
an update, because I'll only record that he has duly made the payment.
Yes, sir, they are doing it, my lord. They are doing it. It will be done.
And kindly do it, otherwise.
It will be done, my lord. It will be done. It will be done.
Mr.
T. Kashyap.
D. Kashyap, the learned counsel appearing on behalf of the petitioner, submitted that in pursuance to the orders passed by this court. Where did I pass orders? Somebody else took up the matter. Oh, passed by this court on 25/11/2025, the amount of rupees 23,33,520 have already been deposited. Full stop. Mr. Arbo Pujari, the learned standing counsel of the Revenue Department, submits that in pursuance thereto, steps have been taken and an update would be placed before this court on 31/2026. List accordingly.
I'm so obliged.
Should the petition may be closed since the respondents have complied with the order dated 3/1/2023 passing passed by this honorable court in WPC.
Oh, what is your name?
And Goa.
M. Burua. You are there in the case?
Your Lordship, appearing on behalf of proceeding.
Well, orders complaint.
Mr. Bidas,
Yes, my lord.
appearing on behalf of the
APDCL, my lord.
respondents,
Yes, ma'am.
submits that the order has been complied with. Order dated? Order dated 3/1/2022, passed in WPC number 1241/2020 have been duly complied with.
Petitioner number 2 is serial number 11, my lord.
And in that regard, I can keep this on
Yes,
record. And in that regard, have placed before this court a communication dated 8/8/2025, along with the enclosures. The same is kept on record and marked with the letter X, taking into account the above, the instant contempt proceedings stands dropped.
Obligement.
Your name, M. Burua. I'm Buhari. Your meeting. Yes. None appears, list the matter after 2 weeks. Yes, Mr. Botagu?
So review of the impugned order is pending, my lord. It has been admitted. The delay has been condoned, my lord. There is an order of this honorable.
So no stay.
Stay not given, my lord, but there is
Okay,
a-
list this contempt with the review.
Yes, that can be.
List this matter along with the review petition number.
Petition number?
Number is not there, I think. Released on the number.
Delay was condoned, my lord, but the number has not been given, my lord.
List the matter of 2 weeks. Yes, Mr. Solia.
Lordship, here, Lordship, in item number 45, Lordship, here I need some time because it is regarding finalization of pension of the petitioner. We have, Lordship,
When
moved
did you
the,
retire? What?
no, 2000, Lordship, the order is of 22, Lordship, here. There's some issue. is-
That is a different thing, 2022 and all these things, but the question requires, my goodness. A person's pension.
Lordship, look.
Is the party correct?
Yes, Lordship. There, Lordship, for here, the promotional post of the petitioner, that has been regularized, Lordship. Now regarding the payment and finalization of pension, Lordship, they
2
have
weeks.
moved an e-file, Lordship.
Let's have it on 16th of February. for an
Lordship,
update.
Part, they have filed an affidavit, Lordship.
Yes.
There was a direction from this honorable court to regularize the period from the date of.
No, Mr. Mohan, wait. That is why I'm taking up the matter by myself on
Lordship.
16th. List the matter on 16/2/2026.
Lordship.
At the request of Mr. Asolia, who submits that some further time is required for the purpose of fully complying with the directions passed by this court in the order dated 1/2/2022 in WPC number
3136.
3136/2020 and 267 and okay, one only, na? And
No.
26.
Common order in petitioner.
How many petitioner here?
One petitioner, two lead petitioner.
The second petitioner, okay, and 2673/2020. Mr. Bora,
The order has been complied with, my lord. Lords will, the document, my lord.
He is supposed to get
The learned counsel appearing on behalf of the petitioner submits that the order passed by this court dated 9/1/2023 in WPC number 5918/2022 have already been complied with.
Lordship, is the second page, my lord. Serial number 6. First page is the for SBI account, second is the other bank account, my lord. Serial numbers, I highlighted it, my lord. He is supposed to, earlier he got 10 lakhs and odd rupees. He was supposed to get 22 lakhs and thereafter he received 12
Areas
lakhs.
to be paid. Have you paid or not?
All has been said. This is account, it has been paid on 18/9/2025. Lordship will see the seal, my lord, in the first page. All have been credited to their respective account. Not only him, there are other
Paid
persons.
amount have been duly paid to the petitioner and the petitioner's entitlements have been duly paid. So considering the above, in that regard, he has placed before this court a set of transfer vouchers, which is kept on record and marked with the letter X. Taking into account the above, the instant contempt proceedings stands dropped.
We have filed an objection to the miss cases today, my lord, we have filed.
You filed?
Yes.
Mr. Ibotakur, the learned counsel submits that objections to all the miss cases have been filed today. However, the same are not on record. Leaves the matter on 23/2/2026 along with those objections. Liberty given to the petitioner to file reply if any.
This is for implementing of party respondent. Implement petition, madam.
What implement?
Party respondent number 2. Are there,
Chalo, release this matter again on, last time when the matter came up, you were not present. Okay. Implement petition, we do one thing. This is Jal Jeevan. This is bench 4 or bench 5 matter. Why are you making bench Jal Jeevan?
now.
What is the case about? Huh?
Order of the court and see.
Salary?
Salary already paid, but continuation of his service,
Okay. ठीक है.
partly comply.
This is an application filed under file seeking implement of when did you issue notice to the Jal Jeevan? 12/6/2023. And you filed this application when? 8/10. How is it possible? We'll look into it later on. It's the matter again on 9/1/2026. We'll have a look at it. Because your question of limitation will go away.
For correction of a fair person. I had challenged them on the dismissal order, but in the expedition.
What error? Which one?
I have challenged them on the dismissal order, but in the fair person order, I have written as well as termination order. Instead of termination, it's really dismissal. order.
Oh, you want to amend your prayer?
Fair person.
Okay, where is the pending? Oh, so this one you want to indicate? Okay. আজি এটা কেছ এটা মই এইটো ডিছপ'জ অফ কৰিছিলোঁ কোনোবা এমেণ্ডমেণ্ট কৰা এটা ৰাতিপুৱা এটা কৰিছিলোঁ না এমেণ্ডমেণ্ট এলাউ কৰিছোঁ 7 দিন সময় দিছোঁ মোচনত আহিছে এই বিডি কোৰৰ কেছ এটা আছে চাওচোন সেইটোৰ লগত মিলাই পেলাই এইখন এলাউ কৰি দিব and he will file within 7 by 21st amended petition. We have allowed the এইখন এলাউ কৰি দিব সেইটো অৰ্ডাৰৰ লগত মিলাই লওঁ. What is this? Accountant General is filing? For deletion of year. Okay. This is the matter after 2 weeks. We go,